pronouncement of judgment. Item number 50 for criminal petition 239 of 21.
For reasons mentioned in the judgment, June 4th.
Make please alert. Item number 41. Bail hearing. In the first list, our case number 3623 of 23 is found. But actually, I have checked the file. It is 22 that matter has been listed, and that was fixed today. But our matter has been fixed on 10/11.
This 3623 is not fixed today.
Not fixed today. On 10, it is fixed.
Wrong file came, my lord. It is in the cause list 3623, but the file came 3623 of 22.
22.
Wrong file came.
Okay. Court master will find out to bring the right file.
But,
The court master will bring the correct file.
but correct file not fixed.
That is not fixed today, my lord.
Not fixed today. On 10th, it is fixed. I have the order.
No, 3623 is not fixed today.
Not fixed. Of 23, not fixed today. But 22 fixed today, which is in the file.
Okay. These parties are also different. Jalal.
Different.
Now, which file we have received?
File is there.
Jalal Sheikh's file is there.
No.
No. Let the correct file come. If it is not fixed today,
I have the order itself.
no, this is wrong file. This is wrong file.
This is the right file, but in the first list is wrongly quoted as 23 instead of
No, we
20.
will go as per cause list, what is listed in the cause.
Right.
So if the date is not fixed today, we will refix it on the date on which it is fixed.
On 10.
On 10th it will be fixed.
May I please elaborate? My lord, I beg to mention for listing a regular bail effect for tomorrow.
What?
Tomorrow.
No, what is the
My lord, I am a high diabetic patient, my lord.
what offense is it on?
My lord, offense is under
Because this court is taking up only bail matters more than 7 years, where the offense alleged is more than 7 years.
my lord 409. 409. I was 7 years.
Okay.
May it please your lordship. Item number 51, I'm praying for an adjournment as Mr. Senior Advocate Mr. R. Sharma is out of station, your lordship. 51.
Miss, what is your name?
P. Fukan.
Miss P. Fukan, who prays for an adjournment on the ground that learned counsel Mr. R. Learned Senior Counsel R. Sharma is out of station. Considering the ground mentioned by the learned counsel, if there is allowed, let this matter be listed after 2 weeks.
A pleasure.
May I please repeat? My lord, item number 16. After carry not received. We are in interim. Another case is fixed take with my lord, item number 15 and 16 out of the same affair, my lord. I am appearing for item number 16, my lord. And in part of the matter, we are in both cases. My lord.
Who is for 15?
15 AFNU Mullah.
I will inform him. my lord. I know.
Same case, but 3 not fixed today.
Heard Mr. A. Paramani. Also heard Mr. K.K. Parachar, learned counsel for learned additional prosecutor, who prays for another date for producing the data where is allowed. Let this case be fixed again on
November 22nd, my lord.
22nd November.
Highly related.
You are on interim.
We all are in.
The
Both
interim order shall continue till the date
Highly.
in 15 and
May I please my lord, I wish to mention item number 57, my lord, the supplementary list. Submission 57.
Yes,
My lord, to just some personal difficulty, my lord, at the airport. So, my lord,
heard Mr. P. Bora,
I think over.
heard Mr. T. Gogoi, learned counsel for the petitioner, who prays for an adjournment due to some personal difficulty. Prayer is allowed, let this matter be listed after 2 weeks.
Hello, may I please? Even item number 35, I am for the informant. We have filed our objection yesterday. Let me be called for you.
Yes. Okay.
May I pick it, Lord? In item 6, my lord, LCR is received. My lord, I may be allowed to go to the LCR, my lord, maybe taken at 2 p.m.
6 at 2 p.m. Okay.
May I please, petitioner item number 25, my lord. My Kenter was confirmed but has not been received, my lord. Can be on 10th, my lord. This Friday because it's from Gitanagar, my
Is there any? Not
lord.
received.
Try, my lord.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Parachar, who prays for another date for everything. Get prayer out. Let this matter be listed again on
10th,
10th of November.
this Friday. Deeply obey.
For motion item 55 of supplementary list.
Call it after something. Or at 2.
Item 56.
May I please, your lordship? Lordship, one connected matter is listed today, lordship, arising out of the same affair. Item 37. If it is available, lordship, this matter may be also taken on that matter.
Whether in item number 37,
CD received, my lord. Item number
okay, we'll take it up with okay.
Along with this matter.
37.
Call this matter along with 37.
Item number 1 for admission.
Leading counsel, Mr. Priya is out of station for some emergency matter. Can be possible for the
Heard Mr.
NZ short.
N.
NZ shortly from Mr. ARP.
NJ03, who prays for an adjournment on the ground that the leading counsel, Mr. ARPI, is out of station. Out of station. Who is appearing for the respondent side? You have informed, none appears. Also heard Mr. P. Lord Thakur, learned additional public prosecutor. Considering the submissions made by learned counsel for the petition, there is a
There is an interim.
let this matter be listed after 2 weeks. After 2 weeks, the interim order shall continue.
Much obliged.
Item number 2. May I please, your lordship? As per office order dated 29/9/23, service report is not complete. We have taken,
When have you
Justice
taken
service.
step?
yes, lordship,
When have you taken step?
4/10/23.
4,
4/10/23.
4, 10.
10.
Okay, we will wait for the third Miss
Yes, correct.
S. Parker, learned counsel for the petition. As per office note dated 6/11/23, service in respect of respondent number 2 is yet to be received. You have taken service to Dusty also.
Yes, lordship.
You have not submitted affidavit. You may file it.
We're going to file it.
Okay. await service of court. Learned counsel for the petitioner also submits that they will be filing an affidavit with regard to the serving of notice of the respondent number 2 by the petitioner. The prayer is allowed. Let this matter be extended after 2 weeks.
Okay. Item 3.
That's too much. That's too much.
Item 57 of supplementary list.
57.
57 already adjourned, my lord. 57 already adjourned. The matter.
For bail hearing, BA item 4.
May please your lordship, this is 439 application, my lord. Or when on the last occasion, I mean, the date before the last occasion, my lord, the lordship has called for the scan copy, my lord.
Scan copy not yet received, my
My lord,
else here.
now the case has been committed, my lord. As per my instruction, my lord, case has been committed, my lord. The petitioner is in jail for 106 days.
Case has been committed
Committed, my lord. Recently, it has been committed
to the court of
in the court of my lord, Second Judge Nogao.
So we'll call for this scan copy from the session judge. You have
My
to,
lord, may I pray one thing, my lord? My lord, instead of my lord calling my lord, my lord, it may be disposed of with a direction that I may file an application. So it is committed,
Yeah.
my lord, I may get bail, my lord.
How-
It's a certain observation
Okay.
of my submission.
Okay.
That, my
heard
lord,
Mr. M. Abdullah Pir, that the counsel for the petitioner. Also heard Mr. P. Godhakur, and the additional public prosecutor. It appears from record that by order dated 17/10/2023, the scanned copy of the case record of Uloni PS case number 446/23 was called for from the committal court, that is the court of London, SDGM Kolyabur. However, same has not yet arrived. On the other hand, learned counsel for the petitioner submits that in the meanwhile, the case has already been committed to the court of London, Sessions Judge Kamru,
Nogao, my lord.
Sessions Judge Nogao, and in view of the committal of the case to the London Sessions Judge's Court, learned counsel for the petitioner submits that the petitioner may be allowed to approach the learned trial court and for praying for relief of bail before learned trial court. Stop. In view of the submissions made by learned counsel for the petitioner, this bail application is disposed of with an observation that the petitioner may approach learned trial court and may pray for regular bail before learned trial court is by bail.
Same shall be disposed of, my lord, in accordance.
That will be
My lord,
not
oblige, my lord.
Item number 5.
Okay, the right.
I'm the petitioner Miller, hearing that the petitioner was defaulting in appearing in the court below Millard. So Millard, he appeared in the court and thereafter he is arrested Millard. He has arrested Millard on Millard first of August 2023, LCR was called for, LCR has come. Until then, Milord, today Milord 98 days I am in custody. 44.
When you defaulted,
And depending Milord on kindly see, order is there, Milord. Nineteen.
you were granted bail.
Yeah, earlier he has granted me, Milord.
You were on bail.
I was in bail. But sometimes I was defaulted. As because I am a poor member, I went to the what Milord, Kerala. And after coming, Milord, I contacted with my advocate. Advocate told me that there is a default. So I appear in the court, Milord. Then Milord, I am arrested.
Charge sheeted case.
Not even kidnapping. And now Milord, I am in custody. And today Milord 98 days, 44.
But the scan copy of case diary has been sent.
So actually LCR has come.
received, Milord.
LCR is also there.
LCR has come.
Scan copy of CD is there.
CD.
I have flag mark.
Okay. Here, more than CD actually, because he was on bail.
In that case, Milord, LCR is required.
LCR has come.
But from the case there,
No, I have a college, I have seen that there is LCR is there.
LCR, no, only case there is there. Only scan copy of CD is there.
Actually, no, let him appear. If he
And the boy has been recovered, Milord, but ransom amount was that is the allegation.
he was on bail.
That is not on merit.
What is the where is the order of your cancellation of bail? Where is the order of your sending you to custody? You have any?
Yes, Milord. Kindly see Milord, page 16.
It's 16.
Page 16, except 3. May I read, Milord?
Yes.
From here, Milord, second or third paragraph, hard both sides. In middle, Milord, it is seen that after accused was released on bail on 25/11/2019, he jumped bail on 21/3/2022. Thereafter, on 19/9/22, he appeared and was allowed to remain on previous bail. Again, on 16/11/22, the accused jumped bail and NPW was issued again was issued against him. Thereafter, on 1/8/2023, he appeared before the court on being produced by his bailor, who withdrew himself to be a bailor of the accused of his presence in the court. Learned counsel for the accused Ratan Devnath has also withdrawn his Bharatnama because of his erratic behavior of the accused regarding appearance in the court. It is also seen that on several occasions, witnesses were returned back only because of the absence of the accused Milord, without.
You are not cooperating in the trial.
Actually, Milord, what I have seen, I have explained clearly, Milord. I am a poor person. I went to the work, Milord, for there, Milord.
But so you were granted bail twice by the trial court.
Once was considered, another was granted bail, another was Milord.
And case is pending since 2019.
And there is an observation that
Yes, that is there.
because of your conduct, the witnesses were returned. Witnesses came to court, they could not be examined. Now,
I am agreeing, Milord, that for my conduct, Milord, case is delaying court is today. I am agreeing, Milord. So,
Then why you should be-
I will be allowed, and if the second time you are coming, Milord, with the similar position, then Milord, I will not pray for bail. Only this time, Milord, can be allowed.
This, yes, Mr. Pal, because
No, case is pending since 2019 and due to this.
he was sent to custody because the bailor withdrew.
Now I have to go and trace bailor.
Since 1/8/2023, you are behind the bar.
My Lord, exactly.
How many days?
Today, Milord, 98 days, Milord. Approximately.
And what is the stage of trial?
Trial, Milord, evidence has not really started.
Evidence has not yet started.
No, LCR is not there, Milord. Only case there is there.
Oh, no, he may
I
be
could not
knowing.
ascertain. Yes. We have to, Milord.
LCR is coming again, it will be delayed. So my only, Milord, within short 8 minutes, so I will be allowed to go and the trial will be completed. And if I am again Milord, defaulting in future, Milord, Your Lordship may also make an observation.
Let him pay some cost.
He is a poor
1 lakh
person working
rupees
as a labor, my lord. So, and now he
getting-
one for 100 days in jail. So,
Heard
cost
Mr. A.K. Talukdar, learned counsel for the petitioner, also heard Mr. D. Das.
A Rashid, not like a
Only A. Talukdar,
A Rashid.
A. Rashid,
And this is item
So-
number
so-
4-5, my lord.
heard Mr. A. Rashid, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure has been filed by the petitioner Mukhtar Ali Khan, who has been detained behind the bar since 1/8/2023 in connection with Sessions Case number 47/2020/2019 /2019 pending in the court of learned Sessions Judge Bongaigaon. Stop. Learned counsel for the petitioner submits that the petitioner was earlier cooperating in the trial, and he was also granted bail by the learned trial court. However, as he is a laborer, he went to Kerala for
Livelihood.
his livelihood and defaulted in appearing before the court, and the learned trial court issued non-bailable warrant of arrest. Learned counsel for arrest against him. Learned counsel for the petitioner has also submitted that the petitioner appeared before the learned trial court on his own on 1/8/2023. It is on 1/8 or 1/8/2023. However, as the bailer, his earlier bailer withdrew himself from the bail, withdrew the bail bond which he executed for the petitioner. The petitioner was remanded to custody. It is submitted by learned counsel for the petitioner that he has been detained behind the bar since last 98 days, and still the trial has not yet progressed. It is further submitted by learned counsel for the petitioner that the petitioner shall cooperate in his trial if he is allowed to go on bail. Stop. Considering the fact that the petitioner has been detained behind the bar for a long period, and he himself surrendered before the learned trial court, as well as considering the circumstances under which he defaulted to appear before the court, this court is of considered opinion that his custodial detention may not be necessary if he cooperates in the trial henceforth. Stop. In view of above, the petitioner Mukhtar Ali Khan is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of learned Sessions Judge Bongaigaon, who may, if so required, impose additional condition on bail. Additional condition of bail at the time of accepting the bail bond. With above observation, this bail application is hereby.
Item 7 and 8. Lordship, pending
After some time.
Yes, they receive money.
Okay.
Yes, they will.
Item 9,
Item number 9, my lord, case diary not received. Okay, thank you.
Yes,
My lord, is handed for last 51 minutes.
but case diary has to be perused. What is the offense?
Offense was stealing a mobile.
Mobile stealing. On
392. Under
Oh.
section 392.
Let the case diary arrive.
Yes,
Third, Mr. M. Hussain,
Award.
A. Wadud, learned counsel for the petitioner, also heard Mr. P. Borthakur, learned additional public prosecutor, who submits that though the case diary was called for, however, claim has not ended, and prays for another date for producing the case diary. Prayer is allowed.
51 days. On my lord, 14/11.
Let this case be again fixed on
My lord, another case is.
90 days. open.
fixed on
14/11/25.
okay
And
on
another death notification.
Then on my lord, 21/11, my lord,
21/11.
21/11.
Let this case be fixed again.
item number 10,
May it please your lordship. Like CD was called for, it is not received, but you, if your lordship permit me to place the matter. before your
LCR was
lordship
called for, my lord, and LCR not yet
For
received.
consideration, my lord, because the petitioner 90 days in custody. And your lordship called for the CD on 16/10/2022. It is before vacation.
No, it is a charge sheeted case.
It is a charge-sheeted case, no doubt, my lord.
Why the trial? Because on last occasion, the court felt that case diary, that the perusal of scan copy of the case record would be necessary. At which stage it is pending?
My lord, charge sheet has been submitted against
In
me, my lord,
committal court.
supplementary charge sheet was submitted. So I filed a petition before session judge as per direction of the Honorable High Court. So session judge rejected my bail petition. What happened, my lord?
On what ground?
That there is material. Now, my humble submission before your lordship, I am not named in the FIR. Total 19 accused persons were named in the FIR, and they all succeeded, my lord, and they appear before the trial court. They in the stage of trial, my lord, they were issued summons for appearance. Now, what happened, my lord? A supplementary charge sheet has been submitted against me, arresting me. Now I have completed 90 days. So, my lord, my humble submission before your lordship,
What has happened to other accused persons?
my lord, these accused persons, they were summoned.
They are on bail.
They all are on bail. All are on bail. They were summoned. They did not appear till date. So, my lord, my humble submission before your lordship, there may be some materials against me. There may be serious allegation against me. But thing is this, my lord, as the supplementary charge sheet has been submitted, I was not the named accused, my lord. But further detention will be reasonable, my lord. For 90 days I am in custody. Because, my lord, I will face trial. Anyhow, my lord, what offense I have committed? Every materials is collected, nothing to be investigated against me. So by keeping in custody, my lord, what benefit will come?
The charge sheet is submitted in the earlier case.
Charge sheet is submitted against 19 persons, my lord.
The additional charge sheet has.
Additional charge sheet, supplementary charge sheet has been submitted against me.
Okay,
And I also submit before your lordship in the supplementary charge sheet.
but where is the material to show that other
Yes.
co-accused are on bail?
Yes, my lord, I'm giving you. All accused persons are on bail.
Show me.
Thus your lordship will bear with me. For the two like that. Huh? Page number 1.
Your case has been committed to Sessions Court or it
Yes,
is,
yes, ma'am. Not committed, madam. It is in the SDGM's court, madam. My lord, I am giving. My lord, your lordship will turn to page 46. Bail or no? My lord, your lordship will turn to page 62. On perusal of CR, I find it proper to proceed with the case under section so and so against the accused persons, namely Aminul so and so, total 18, 19. Accordingly, cognizance is taken, issue summons to the accused persons. So, my lord,
No.
they are to be appear before the court because they are on bail. All are on bail. So summons has been issued to them. Now your lordship would be pleased to see,
where is the charge sheet?
my lord, charge sheet, my lord, I am giving. Charge sheet at page 17, my lord. From bottom, my lord, 1, 2, 3, 4, 4 lines, my lord, from bottom.
This is the additional charge.
Investigation of the accused, Kamaluddin Sheikh, supplementary, my lord. Supplementary charge sheet I am giving.
Yes.
Page 70, 17, my lord. 70, my lord. My lord, 70, my lord. I want to point out only last paragraph of page 70, my lord. It is stated like this, my lord. During investigation, your lordship got it. During investigation, last paragraph, my lord.
Yeah.
During investigation of the case, as I was directed by the Honorable OC of this police station to arrest accused summarily in the case and directed to submitted charge sheet against him. So I arrest accused summarily, acknowledged on so and so and submitted this also. So, my lord, my humble submission before your lordship, IO, if found materials against me, my lord, then I may be arrested. But here it is seen that on investigation, I was not arrested. I was arrested on the direction of yours. Anyhow, my lord, my humble submission before your lordship, charge sheet has been submitted against me. So I will face the trial. What benefit will come, my lord? What benefit will come keeping me in custody more than 90 days? Nothing is there, my lord. I'll face the trial. Like other 19 accused persons, my lord, those who are on bail.
Where is the charge sheet as regards other 90?
Yes, my lord, that I have already placed before your lordship. Page 70. No, 17, page 70. Page 17, my lord, from bottom, my lord, 4th line. These are the accused persons. Total 19, my lord.
No, I just want to know that from where we will know that they are on bail, apart from the order that court has issued some.
They are on bail, my lord. Bail orders I have annexed, my lord. Your lordship. will
That I
turn
am
to-
asking you.
Yes, my lord. Your lordship will turn to page 46. 46 to 60, my lord. All bail orders.
They were granted bail by this court.
My lord,
Okay, okay.
this court, my lord, one person was granted.
By High Court.
By High Court, and anticipatory bail also granted for one person.
Yes, Mr. Bhattakur.
My lord-
Other co-accused are on bail.
Anyway, but my lord, in this case, the present accused person against him additional supplementary search sheet file. Police has every right to file additional search sheet.
Yes.
On the other hand, my lord, petitioner has
not
submitted
denied
that, my lord. There may be sufficient material against the accused. There may be a serious offense, but on the other hand, he prayed for bail, my lord, as because 90 days already completed. After filing search sheet of the bail, so in although 90 days completed, in fact, my lord, although there is a direction from the OC and thereafter, my lord, IO has submitted the supplementary search sheet. In that ground, for that reason, my lord, I want to go through the my lord LCR with
No,
statement of the witnesses, my lord. What are the materials against the present accused person for which my lord, scan copy of LCR is required? my lord.
Charge sheet is there.
Search sheet is there, but my lord, statement of witnesses is
Out of 20 accused, 19 are on bail.
probably thereafter, my lord, because my lord, during investigation, it revealed that he may be, my lord, one of the main accused. Thereafter, police has submitted OC, probably directed why you have not lost search sheet
No
against this
question of
person.
probability because the charge sheet is there. You go through page 70.
Page 17, yes,
What-
my lord.
Page 70, 70.
Yes, I have gone through that search sheet, my lord.
Last paragraph.
Last, as per the direction of the officer in charge, my lord, this supplementary search sheet filed by the IO of the case. That is the, my lord, during investigation, I am directed by the. So
In the
what?
charge sheet, it is mentioned that he is also involved.
Yes,
No specific allegation.
not specific.
There are materials against him.
Yes,
Therefore, charge sheet.
and
has
to
been-
find out those materials, my lord, what are the materials for which, my lord?
No, that is not required at this stage when other 19 accused are on bail. When there is no specific allegation that he is the main accused, no such allegation is against.
Then, my lord, where
He is
from
one of the accused.
one of the accused already, on my lord, 19 persons, my lord, although they are on bail, my lord, on what ground probably at that point of time.
Bail orders are there on record.
Yes.
What-
Yes, because earlier, my lord, probably at that point regarding these accused persons, my lord, while after perusing the case diary, probably, my lord, against these persons, my lord, after perusing the case diary, my lord.
Where is the rejection order? Bail rejection order? There would be certainly
88
materials against them because therefore
Yes.
charge sheet has been
my lord,
Submitted,
80
yes.
88 page.
page number 88.
My lord, last one. Last bail rejected by additional sessions.
What is your name? The name of the accused is
Sumar Ali.
Sumar Ali alias.
Yes, Ganesh.
Jahan Ali. Is the main.
My lord, last portion, my lord, page 89. After perusing the record, it appears that IO has already submitted additional charge sheet against so and so, edit section. There are sufficient incriminating materials found against the accused Sumar Ali alias Ganesh.
Yes, material would certainly be there.
Yes.
Therefore, charge sheet has been.
My lord.
Yes.
My lord, only one point is your lordship permit me. What my learned friend submitted, my lord, that there may be incriminating material against me more than the other accused person. I humbly submit before your lordship. In the FIR, there is 18 person named, my lord, but I am
You
not
are
named.
not.
I am not named. So, my lord, here it is seen, it is a market, my lord. If I was involved, my lord, definitely among the 18 persons, my lord, my name would have been there.
No, I will leave it to your lordship, my lord.
Okay. How-
Lordship may pass it
How
to me.
Mr.
Much only.
How Mr.
M.A. Sheikh.
M.A. Sheikh, learned counsel for the petitioner, also heard Mr. P. Bothakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sumar Ali Ilyas Ganesh, who has been detained behind the bar since last 10/10/2023. Since last how many days?
90.
Since last 90 days. In connection with Bilasipara PS case number 265/2022, corresponding to PRC case number 861/2023 under section 447/427/526/326/34/302 of the Indian Penal Code. The gist of accusation in this case is that on 22/8/2022, one Shah Alam Haq lodged an FIR before the officer in charge of Bilasipara Police Station, inter alia, alleging that one Shah Jahan Ali and 11 other accused persons named in the FIR armed with deadly weapon assaulted. Who was assaulted? Assaulted the elder brother of the first informant, namely Sofiluddin Sheikh, and caused serious injuries on his person. Stop. The FIR was initially registered under section 447, 427, 325, 326/34 of the Indian Penal Code. And later on, who died? Sofiul died. Later on, the injured succumbed to his injuries. Injured Sofiluddin Sheikh succumbed to his injuries, and section 302 was added to the FIR and investigation proceeded. On completion of the investigation, charge sheet was laid against 19 accused persons. Stop. Learned counsel for the petitioner submits that the present petitioner was neither named in the FIR initially nor charge sheet was laid against him at the first instance. It is later on, after further investigation, an additional charge sheet was laid on 10/8/2023, wherein it is 10/8/2023, wherein it is stated that during the course of further investigation, it was found that the present petitioner, namely Sumer Ali alias Ganesh, was also involved in the offense involved in this case. Stop. Learned counsel for the petitioner submits that out of the 19 other accused persons against whom charge sheet was laid, all the accused persons are on bail. they were granted bail by this court. And one of them was granted anticipatory bail. So, learned counsel for the petitioner has further submitted that the committal court has, where is the order of the committal court? The committal court of learned SDJM within bracket M Bilasipara has issued summons to other 19 accused persons,
Case 62.
but they have not yet appeared before learned committal court. On the other hand, the present petitioner has been languishing behind the bar since last 90 days. Considering the fact that the co-accused, all the other co-accused of this case have already been granted bail, this court does not find any justification to keep the present petitioner behind the bar if he otherwise cooperates with the trial. So, in view of above, the present petitioner, namely Sumer Ali alias Ganesh, is allowed to go on bail of rupees. What are the bail conditions of other court? Rupees 30,000 with one surety of like amount subject to the satisfaction of learned,
Conditions at page 49.
subject to satisfaction of learned
SDJM Bilasipara.
M Bilasipar, with a condition that he shall regularly appear before the learned committal court as well as learned trial court when the after committal of the state case, and shall cooperate in his trial with above observation with bail application.
Item 11.
For 39 bail application. Petitioner was arrested on 22nd. Today is 24 days.
22nd,
22nd night,
how many days?
44 days.
What is the offense?
Offense is 304.
CD has
CD available, but postmortem report is not available. As per the statement of the witnesses, what happened, the accused he has illegally electrocuted his boiler farm, and this disease was working in that farm. While working in the evening at about 6 p.m. he was electrocuted and he died. And there are 6 number of witnesses, they stated that when they went to the when they even tried, and they went to the house of the accused and saw that this died inside the boiler farm, and they subsequently informed the police. Inquest report is available, but PM report is not yet available. PM report is
but
not-
otherwise we can assume that he died due to electrocution.
Yes, and the epidicial report is there, in that report, the epidicial authority stated that the farm was illegally electrified from domestic household line from Corona Bora bearing the consumer insurances, and for that epidicial is not in fault. So this is the report of the epidicial SDO Sotia of epidicial.
No, is it a case of intentional or accidental electrocution? What the witnesses? Witness, the statement of witnesses have been recorded.
They stated that it is boiler farm দেখা পাম উশাহ নিশাহ নোৱা নাছিল তাক দাঙি আনি ঘৰলৈ ভিতৰত থলো ultimately the farm was maybe illegally electrocuted because of to prevent some shift and all this, and this person is
He went to mend the boiler
he-
chicken.
he's working on the farm, exactly. It's accidentally, but that act is illegal,
Maybe, but does not seem that further custodial detention.
yes,
Uh,
after all, it's an
44
accident.
days.
42 days,
How many days?
44 days.
No, since 20,
27/9.
27/9, huh?
Heard Miss
Tirasqua.
T. Rajpa, learned counsel for the petitioner.
Okay.
Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Sri Koruna Bora, who has been detained behind the bar since 27/9/2023 in connection with Stutia PS case number 98/2023 under section 304 of the Indian Penal Code, corresponding to GR case number 439/2023. The gist of accusation in this case is that on 26/9/2023, one Shri Rakesh Munda lodged an FIR before the officer in charge of Itakola Police Outpost, inter alia, alleging that the petitioner illegally took electric connection, illegally planted electrical wire in the wall of the commercial boiler farm, and when the uncle of the first informant, namely Rajesh Munda, who was working as an employee in the said boiler farm, of which the present petitioner is the owner, when there he got electrocuted and later on succumbed to his injury. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar since last 44 days, and he has not intentionally caused the death of the uncle of the first informant. On the other hand, learned additional public prosecutor has produced the case diary of Tritiya PS case number 98/23 under section 98/23 and has submitted that the electrical connection in the state boiler farm was illegally taken without approval of the APDCA.
Yes.
Learned additional public prosecutor also submits that there are discriminating materials against present accused. So, I have considered the submissions made by the counsel for both sides as well as perused the case diary of CPS case of 98/2020. Though there appears to be some incriminating materials against present accused person. However, it appears that the investigation has barely progressed and statement of witnesses have been recorded by the investigating officer. It also appears that the petitioner has been detained behind the bar since last 44 days. Hence, considering the progress made in the investigation as well as period of detention already undergone by petitioner, this court is of considered opinion that if he cooperates with the investigating officer in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of the case. Hence, stop. In view of above, the accused Shri Karuna Bora is hereby allowed to go on bail of ₹30,000 with one surety of title, subject to the satisfaction of learned Chief Judicial Magistrate, CJM, where Bishana, learned Chief Judicial Magistrate Bishana, with a condition that the petitioner shall continue to cooperate in the investigation. With above observation, this bail application is also.
Item 12,
Well, my lord, case there is not testimony.
49 days, my lord, 46 days, my lord.
What is the offense?
Offense, my lord, registered, my lord, 364, my lord. And 384,
Let the case very come.
Yes.
my lord. My learned friend may take instruction whether circuit has been submitted, my lord. As per our information, my lord, circuit may file, my lord.
My lord,
That it has been submitted.
my lord, at two, my lord, I'll take the inspection, my lord.
Okay, let him take inspection.
Yes,
At 2, we will take.
Lord.
supplementary item 58,
My lord, could it be taken up at 2 p.m.? I tried to go through the scan copy of the case diary. Some pages are not at all legible, my lord. So I will try
Then let
again,
us-
my lord, at 2 p.m., my lord. Wow. আজকে কি বার? Ah, yes. If he has no objection, we can
Heard Mr. S.
on Friday, my lord, then.
Heard Mr. S. Mani, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who submits that that as some of the pages of the scanned copy of the case record which has been received are not legible, he needs some more time to go through the thing. The learned counsel for the petitioner does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed again on
Friday, my lord.
Friday on 10th of November.
God bless you much.
I have got 2 matters left out. Time being interested, 7 and 8.
Okay.
People will be- 7 and 38.
Is there a receivement?
Oh, one is Lordship arrested, the husband is arrested, and the other 2 are anticipatory bail, that is Lordship father-in-law and mother-in-law. And it is a case of 2016 law, 304B. 2016.
2016.
Husband was arrested on 15/9/23, my lord.
Yes.
That's it. Petition में postmortem is it?
Yeah, the husband was arrested 54 days.
Where is the affair?
FIR Lordship will find on page 10 Lordship.
Why so late arrest of the affair was while in
Was it
2016 itself. You were not here.
No,
Or-
we'll hear Lordship, but the village Lordship, everyone knows that it was not a case of suicide Lordship, so maybe police also Lordship. They are not out of the record.
Is there anything in the
Yes, my lord, postmortem report received, my lord. As per postmortem report, opinion is, my lord, death was due to asphyxia as a result of antemortem suicidal hanging, my lord.
suicidal?
Yes, suicidal hanging. And otherwise, my lord, the present my lord, victim, my lord, he eloped with the present accused person, my lord, in the year, my lord, 2016. Thereafter, within a period of, my lord, 2 years, the my lord, the victim, my lord, victim, my lord, committed
Now,
suicide.
what is the stage of investigation?
Investigation is, my lord, now postmortem report received statement of witnesses is also available, my lord. And as per some of the witnesses, my lord, neighboring witnesses, they stated that, my lord, immediately after marriage, since after marriage, my lord, the accused person and her family members committed, my lord, physical and mental harassment to the victim, my lord. Some of the,
Whether custodial detention is necessary?
at this point of time, already, my lord,
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. P. Bodhakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by Joyanta Das, who has been detained behind the bar since 15/9/2023, within bracket since last 64 days, in connection with Rongia PS case number 581/2016 under section 304B/34 of the Indian Penal Code. The gist of accusation in this case is that on 13/11/2016, one Shri Chakradhar Das lodged an FIR before the officer in charge of Rangya Police Station, inter alia, alleging that her daughter was married. Her daughter had eloped with the present petitioner in the year 2015, and after that she was staying with the present petitioner, and she was subjected to cruelty by the present petitioner and her parents and his parents and other family members for demand of dowry. And unable to tolerate such torture, the daughter of the first informant committed suicide. No, not that. Cancel. It is also alleged in the FIR that though the daughter of the first informant was tolerating the torture perpetrated by the accused person, however, on 12/11/2016, the present petitioner, along with his family members, killed the daughter of the first informant and hanged her inside the room. Stop. Apart from detention, any other submission?
Probably like the old case.
Learned counsel for the petitioner has submitted that the incident occurred in the year 2016, and the petitioner has already been detained behind the bar since last 54 days. Stop. And on the ground of detention itself, the learned counsel for the petitioner has prayed for allowing the petitioner to go on bail. On-
Is the trial of
It is also submitted that the petitioner would face the trial in case of submission of charge sheet again. On the other hand, learned additional public prosecutor has produced the case diary of Rangya PS case number 581/16 and has submitted that from the post-mortem examination report available in the case diary, it appears that the case that the death of the daughter of the first informant was due to
asphyxia,
asphyxia
as a result of antemortem suicidal hanging.
as the result of antemortem suicidal hanging. It is also submitted by learned additional public prosecutor that in the meanwhile, the investigation has fairly progressed and the investigating officer has recorded the statement of relevant witnesses. So, considering the fact that the no, considering the progress made in the investigation as well as period of detention already undergone by the present petitioner, further custodial detention of the present petitioner does not appear to be necessary if he cooperates in the investigation. Stop. In view of above, the petitioner Jointo Das is thereby allowed to go on bail of ₹30,000 with one period of time, subject to the satisfaction of law.
SDGM further Rangya.
SDGM Mufassal, S or M.
S block.
Rangya is not S,
But forwarding report, Lord Shiva, I am saying from forwarding report.
it is wrong.
No,
SD, okay, SDGM, comma, Rangya.
not only think on the forwarding report.
Subject to condition that the petitioner shall cooperate in the investigation. Okay. Next item, heard Mr. S. Muni, learned counsel for the petitioner. Also heard Mr. P. Borthaku, learned additional public prosecutor. This application under section 438 of Code of Criminal Procedure, 1973 has been filed by one Yogen Das, one Shri Yogen Das and Srimati Tewali Das, who are apprehending their arrest in connection with Rangya PS case number 581/2016 under section 304B/34 of the Indian Penal. The gist of the accusation in this case is quote the gist from the earlier case. Learned counsel for the petitioners have submitted that the present petitioners are the father-in-law and mother-in-law of the deceased respectively. It is also submitted that the daughter-in-law of the present petitioner had committed suicide and they are not involved in the offense as alleged in the FIR. In the FIR, it is alleged that they were
But witnesses might also implicated the present
no
accused.
FIR. The allegation is of murder. So, on the other hand, learned additional public prosecutor has produced the case diary of Rangya Police Station case number 581/2016 and has submitted that from the post-mortem report available in the case diary, it appears that the cause of death of the present petitioner, cause of death same as in the other. Stop. It is pertinent to mention herein that the son of the present petitioners, namely Jointo Das, who was the husband of the deceased, has already been granted bail by this court in BA case number 3500/2023. So, further, considering the progress made in the investigation and also considering the fact that one of the main accused has already been granted bail by this court, the custodial detention of the present petitioners does not appear to be necessary for fair completion of the investigation. Hence, both the above named petitioners, namely Yogen Das and Tewali Das, are hereby directed to appear before the investigating officer of Rangya Police Station case number 2016 within 10 days from the date of this order.
Jugenda's statement is also available in the case diary, although they approached before the honorable court for anticipatory bail.
They not arrested.
Not arrested.
Maybe
No.
an initial quantity or eight years.
Let them appear if
Yes,
required.
yes.
But in this case, no interim.
Okay. Stop. Comma. And what was that? And cooperate in the investigation. Stop. Cooperate in the investigation. If they do so, comma, in the event of their arrest in connection with Ronia PS case number 581/2016, comma, they shall be allowed to go on bail of rupees 30,000 with one security of like amount, 30,000 each with one security of like amount, subject to the satisfaction of the arresting authority, with condition that they shall cooperate with the investigation. With above observation, the anticipatory bail application is thereby disposed of.
Much obliged. Much obliged.
Item 59, supplementary.
May I please?
Yes,
My lord, item number 59, your lordship has, my lord, directed me to obtain instruction.
whether they were produced before the-
No, physically, my lord, not produced, but through video conferencing, they, my lord.
They are produced.
Yes, through video conferencing. As per, my lord, various date, my lord, through APP.
physical
Okay.
production is not necessary.
Lordship, yesterday's order, Lordship, 7/11/2023, passed by the learned court. May I read it, Lordship? Just
Yes.
now, Lordship, I got it over telephone. Today, the case was fixed for physical production of the accused, namely secondarily, and for furnishing copy and for committal of the case. The accused is produced me today through video conferencing from the district jail Dhupri. He is remanded back to jail till 2011-2023. Seen the radiogram received from the district jail Dhupri, stating that the accused could not be produced for non-providing of boat/vehicle and issue of fuel from the district administrative SSM. The jail authority is to produce the accused, namely so and so, before this court, so that the case can be committed to the Honorable Court of Sessions as SSM.
No, case can otherwise also be committed.
Yes, Lordship, but Lordship, since last 10 days, Lordship, the case is stuck at the same stage because of his non-production, that to physical. And Lordship, I am there in the custody. Every time, Lordship, the same order is being passed by the learned court below. I have annexed all the other orders, Lordship.
Related direction may be issued to the, my lord, if possible, my lord, then to the trial court to commit the case. Otherwise, my lord, matter is pending since long, my lord.
Yes, sir. And Lordship,
Then
now
thereafter, learned session judge will pass appropriate order in accordance with law, my lord, in case of filing any bail application, my lord.
Otherwise, case diary is there.
It's a
No, my lord,
certificate
case
case,
diary
Lordship.
was not called for, my lord. Scan copy of LCR was also not called for.
Otherwise, Lordship, I have annexed all the orders, Lordship, even orders say certified copy of the
No
order.
charge sheeted case, then appropriate court is the trial court first
Yes,
to
yes.
consider your bail.
That has been rejected. I have annexed the rejected.
So that has been rejected.
Yes, sir.
On what? Let
Ground
us
is
go.
that, Lordship,
Let us go through rejection of
page number 43. Page number 43, annexed calendar. Case record put up
the
to
jail is in
Dhubri, my lord.
Dhubri,
Dhubri,
Lord.
where he has to be produced.
South Talmara,
Hatsingam.
Hatsingam.
So river has to be crossed.
Yes, Lordship, river has to be crossed, Lordship. Earlier, Lordship, it was same district, now Lordship, that has been bifurcated.
And government does not have petrol to.
Yes, sir. And I am there in. I'm a local resident, Lordship. Lordship may alert me on bail, Lordship. That it has already been submitted.
No, where is the rejection order?
The rejection, Lordship, page number 43.
This is rejection by,
Rejection by Chief Judicial Magistrate. Peruse the case record, part 40 side. Case record reveals that this case, IO has filed charges against the
No.
under section.
you have not approached the sessions court because case has not yet been committed.
Yes.
Where is the affair?
Consolidated copy, Lordship, page number 19. 19. This is the case of Lordship 2020.
The allegations are serious.
Yes, otherwise.
So we are issuing a direction to the committal court to furnish the copies to you, to either through messenger or somehow, so that the case is committed on the next day. And after committal, you may approach learned trial court, sessions court for regular bail.
That will also do, Lordship. But may I pray that, Lordship, within a period of 1 week? That's because, Lordship, already 10 days.
What is the next date?
Next date is, Lordship, 2011.
So on the next date, committal order may be so that on the next date,
2011, Lordship, 2011, 2010.
heard Mr. M. Ahmed, learned counsel for the petition. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Sikandar Ali, who has been detained behind the bar since when?
19/6/2023.
19/6/2023 in connection with PRC case number 1145/2023 arising out of Mankasar Police Station case number 745/2020 under section 376D/506 of the Indian Penal Code. It is submitted by learned counsel for the petitioner that the petitioner is detained in Dhubri district jail, whereas the PRC case is pending before the court of learned Chief Judicial Magistrate South Salmara Mankachar. And on how many occasions you were not produced?
Last date was, Lordship, 11th number.
And due to the constraint, why it has not been produced? What reason has been
The
cited?
only reason is that, Lordship, no vehicle, no boat.
Where is the reason?
Lordship may kindly come to page number 39. For Lordship, page number 40. Every order Lordship, the same ground is here. Page number 40. In the radiogram received from the district jail Dhubri, stating that
And the accused and the present petitioner could not be physically produced before the learned committal court due to unavailability of boat slash vehicle to carry the petitioner from district jail Dhubri to the learned committal court at Hatsing. Stop. It also appears from the record of this court that on 26/10/2023, this court passed an order that this court directed the learned additional public prosecutor to seek instructions from the superintendent of police.
Now I have received that instruction from the OC of the concern.
Seek instruction from superintendent of police regarding the fact of this case as to why the administration has failed to produce the petitioner physically before learned committal court when it was so directed by the learned committal court. Stop. Today, learned additional public prosecutor has submitted that he has been informed by the officer in charge of Vilasipara police station that the petitioner has been regularly produced before the learned committal court through video conferencing. However, he was not produced physically before the committal court. On perusal of the copies of the order passed by learned committal court, it appears copies of the order passed by the learned committal court on 29/2023, 4/10/2023, and today's ordering, the order which you have read from
7/11.
7.
And-
Yes, that is 7/11.
and 7/11/2023 passed in PRC case number 1145/23, it appears that the committal court has been regularly, repeatedly directing repeatedly issuing direction to the jail authority for production of the petitioner before the learned committal court, so that the case may be committed to the Court of Sessions Judge South Salmat. However, in spite of repeated directions, said order has not been complied with, and the petitioner was only produced through the mode of video conferencing. Stop. In view of the facts and circumstances of this case, this bail application is hereby disposed of with an observation that with a direction to the district administration South Salmana to physically produce the petitioner before the learned committal court on the next date fixed, that is
2011.
2011
2023.
2023, so that the case may be committed to the Court of Learned Sessions Judge South Salman. Stop. The petitioner may thereafter approach the learned Court of Learned Sessions Judge Bilasipara and Court of Learned Sessions Judge South Salmar and pray for regular bail before the state court if so advised. Any other of the
Lordship, the direction, Lordship, which has been issued to the district administration of South Sapara, that same direction may go to the district administration of Dhubri.
South Salmar and district. A copy of this order shall be furnished to the concerned authority by the registry of.
Although Lordship, the case was registered under section 376D, but subsequently charges was submitted under section 376.
I have received the information from OC Mankasar, not OC Bilasipura. OC Mankasar.
Instead of Bilasipara, remove.
OC Mankasar.
Let us see.
For bail hearing, items 13 and
Highly
14.
obliged.
Item
May it please, sir. The FSL report was called for, my lord.
You are on interim bill. This is an old pending
Yes, my lord. I'm on interim, my
of the year 2020.
22, my lord.
Oh.
In my lord, last year, my lord, the FSL report was called for.
Yes, FSL report received, my lord. And
The FIR is at page 17 in item number 13, AP 2554.
What is there in the What is the case?
My lord, FIR is at page 17, my lord. My lord, the deceased, my lord, he had, my lord, informed us that he was an agent of IndusInd Bank. And thereby he had collected money, Aadhaar card, PAN cards from us, my lord, from the applicant number 2 for giving a auction vehicle, Innova Krista vehicle, my lord, for which an amount of 1,18,000 was taken. My lord, since the vehicle was not given to us, my lord, we called him up. He informed my lord that the vehicle was on the way. Now, on that day, since the vehicle did not come, my lord, my lord, we tried to inquire about the phone number. Our numbers were blocked. Then we went to IndusInd Bank when we found, my lord, that the receipts which the deceased had given were fake and forged. Now, my lord, the allegation, my lord, is that this the deceased.
Where is the FIR?
My lord, page 70.
17.
17.
Yes.
My lord, with due respect, I would like to bring to your kind attention that since last Friday, 15/7/22, from about 11:40 p.m., I was not able to get in touch with my son, Yasik Zaman, aged about 28 years. Despite my repeated attempts to contact him, the calls went unanswered, phone number so-and-so. A short while before that, around 11:15 p.m., my nephew, Anish Zaman, had informed me that 4 men, along with a woman, had gone looking for Yasik to my house, and while doing so, they had created a scene in front of my main gate.
Who is the deceased?
Yasik Zaman.
Yasik is
Yasik
the
Zaman. On top of that, they called him over phone, threatening to kill Yasik if Yasik did not come out of the house. The boys were Iftikhar Khan, my lord, applicant number 2 in this case, Aftabur Rahman, Shahrukh Khan, and Pablu of Jorhat, and an unidentified woman. Since I had gone to visit my daughter who stays at CD Road, Lakhimpur on Thursday, 14/7/22, my son Yasik had left all alone in the house. I returned home following Monday. And my lord, this line is important, my lord. And after unlocking the front door, the FI informant herself unlocked the front door. I found my son lying near the back door covered in blood. I suspect that those 4 men, along with Papul Ali and Nasir Ali, residents of Jorhat, had killed my son. Further, they were again seen near our house inquiring the people about my son's whereabouts. And when he comes in and out of the house on Saturday at around 11 a.m., a day after they had killed him. It looks like they had come to see if anyone had found out about what they had done. In fact, Iftikhar Khan, Bablu had openly announced in public that they would kill Yasik if they found him. I would also like to inform you that Iftikhar Khan is my daughter, Nasrin Sultana's uncle's son-in-law. On Saturday, when my daughter called him to invite him to a program, Iftikhar told him that he was not in Lakhimpur, but at that time had come to Jorhat to meet Yasik regarding some car-related dispute. He also told her that Yasik had taken an amount of 1 lakh rupees from him as car booking, but had not delivered him the car till June. After knowing this, I told my daughter to ask him to collect 50,000 from my nephew Anis, and accordingly, Iftikhar Khan had collected the amount of 50,000 from Anis on Saturday, 16/7. Brutally murdered so. This is the FIR. My lord, in fact, I had written to the SP on getting to know of this. My lord, my intimation to the SP is 2722 at page 24-25. My
No,
lord, here, my lord.
before you further
My lord.
submit, what is the progress of the
My lord, investigation is going on. My lord, in this case, entire case, my lord, from the entire case diary, my lord, there are two angles in the entire case diary. From the case diary, in one hand, yes, there is admittedly there is some dispute along with the present accused person regarding some my lord, on the pretext of providing a Innova car from on refinance from IndusInd Bank. He took and the present victim took an amount of rupees 1,80,000, and thereafter he not also returned that money and also the vehicle, and for that there is some dispute between them is there. And my lord, one another angle is there, my lord, the victim also running one, my lord, mobile app for hotel begging along with his colleagues, and his colleagues 164 statement is also available, and from that 164 statement, my lord, it reveals that he is under the victim is under some depression, and he also sent messages that I am going to die, and all these statements are 164 statement of his colleagues is available in the case diary. Now, my lord, and my lord, the present accused persons are also, my lord, your lordship, I just like to point out one
where
note
is
of
your interim bail order?
My lord,
that is also, my lord, I would like to point out, my lord, that note of the IO is
Where?
on the
my lord, date, my lord, 23/11/52.
Yes, you may.
thereafter, my lord, last here note I have seen, my lord, after obtaining interim order, my lord, they have not cooperated with the investigation, not appear as per my lord, note of the IO, my lord. They have not appeared before the IO for recording their statement.
We had, as per my instructions from my colleague in Jorhat, they have appeared. My lord.
Yeah, I would just like to point out one another aspect of the, my lord, investigation. Your lordship might kindly peruse this point and thereafter also, my lord.
No, you see whether they have appeared.
No, my lord, as per the note of the IO, my lord, they have not appeared.
Find out when you have appeared.
My lord, I'll take.
Well, I was just on, that is note is on 21/7/23. So and so যোৰহাটৰ পৰা ডিব্ৰুগড়লৈ এই মোকদ্দমাৰ পৰৱৰ্তী তদন্তৰ ভাৰ so and so পুনৰ প্ৰকাশ থাকে যে উক্ত মোকদ্দমাৰ মূল অভিযুক্ত ইফতিকাৰ খান আৰু আশফাক খানক পূৰ্বৰ তদন্তকাৰী বিষয়াই মোকদ্দমা সংক্ৰান্তে সোধ-পোছৰ বাবে হাজিৰ হোৱাৰ বাবে যোগাযোগ কৰে যদিও পদকীয়াগণ বৰ্তমানেও হাজিৰ হোৱা নাই, সেয়েহে তেওঁলোকক মোকদ্দমা সংক্ৰান্তে সোধ-পোছৰ বাবে যত্নবান থাকিল। And regarding other accused person also, same note is there, my lord. That is the note of the IO.
My lord, in fact, my lord, on that day, my lord, just after this bail order was granted, my lord, I informed my colleague in Jorhat. He had accompanied these accused persons, my lord, to the police. That was my instruction, clear instruction at that point of time last year.
Yes,
And my lord, not only this, the other accused, my lord,
No,
they have been-
after 23/11.
Yes,
22.
after my lord, 13/11/22, one note of 13/11/22 is also there, my lord.
13/11 bail was not granted, my lord.
After
yes.
23/11.
After 23/11, that is my lord. 21/10/23, my lord. Last note, 21/10/23.
After 23/11/22, there is no other endorsement of the
After 23/11/22, my lord.
for last 1 year. Because interim bail was granted 1 year ago.
Yes, we had
Since-
it. I remember my colleague categorically informed me
interim petition display.
It's 23, not 22. That's
23/11/22. It is long ago.
Yes, my lord.
And my lord, there is another aspect from what my learned friend has laid out, my lord. The
Yes.
IO has changed.
Thereafter, my lord, notice after that, my lord, 3/7/23, and thereafter, my lord, last 13/11/22.
Before 3/7/23.
Before 3/7/23, my lord, last notice on, my lord, 13/11/20.
13,
No,
11, 20.
27/20, 13/11/20.
Hmm.
13/11/20. Thereafter, my lord, directly on.
My colleague is most probably appearing in the court as well. Yes.
Who is your colleague?
Gautam Bora and my lord, Rintu Gupta.
Because if you have not appeared,
We have appeared, but that was my categorical instruction. I specifically told them. And they had, in fact, they have nothing to hide, my lord. On 15th,
no, but that was one of the conditions
Yes,
of bail.
yes, ma'am.
If you do
And-
not comply with the bail condition, it will automatically go.
Yes, ma'am. Yes, ma'am, I'm aware of that. And in fact, the other item number 14, my lord, that was granted prior in point of time. I have annexed that bail order also, Monsura.
Your lordship may kindly peruse from this portion to some of the portions of the case diary, my. Otherwise, my lord, it is a fact that after our interim order, my lord, from the case diary, and case diary, one photocopy of the, my lord, interim order is available, my lord. But
Ah.
one photocopy only. But how they that
No,
photocopy
then
is,
you seek instruct.
uh,
No, there is an endorsement that they have not appeared.
not appeared. Yes, not appeared.
So question of seeking.
Yes.
My lord, how did the photocopy come into existence in the police station?
My lord, probably they may collect that because this is a, my lord, vital case. Some, my lord,
My lord, if
You
it is-
seek instructions
my lord,
and file an affidavit.
I will.
on
my
what on what date they appeared
My
before the IO.
On
Uh,
which date you have
yes, my lord.
appeared,
I
then we
will,
will
I
pass on.
My lord, if the photocopy, it's a photocopy of a certified copy, my lord. If it is a photocopy of this particular certified copy,
And my lord, otherwise,
my lord, then it would be apparent that this is the copy, photocopy of
No,
which was
but there
given.
is an endorsement.
Yes, ma'am.
If you have not appeared,
I have
you file an
I will file an
affidavit,
affidavit.
we will pass orders. then.
although my lord, investigation is going on two different angles. Otherwise, from the contents of the affair, he is one of the main accused because there is
No, only to
admittedly.
show that whether you have complied.
Yes,
The
that is
question
right.
of your
Because otherwise,
requirement for custodial interrogation is
Yes.
a different aspect.
I understand.
yes, yes.
You may not be now required.
Although my
But-
lord, because they are the main accused, if my lord they would have appeared, definitely statement of the accused person would have been there in the case diary. My lord.
My lord knows. My
Heard,
lord knows.
heard Mr. P.D. Nair, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who produces the case diary of, who has produced the case diary of Jorhat Police Station case number 635/2022, which was called for in connection with this case. Learned additional public prosecutor submits that though the petitioners were allowed to go on interim bail by order dated 23/11/2022, however, there is an endorsement in the case diary of the present investigating officer that the petitioners have not yet appeared before the investigating officer and have not cooperated in the investigation. On the other hand, learned Mr. P.D. Nair, learned counsel for the petitioner, submits that the petitioners have appeared before the earlier investigating officer and seeks leave of this court to allow the petitioners to file an additional affidavit to bring this fact on record. The prayer is allowed. The petitioner may file an affidavit within to this effect. In the meanwhile, when will you file affidavit?
My lord, they are from Lakhimpur. My lord, in the week from 20th, my lord. Say
Okay.
21st or
In the
22nd.
meanwhile, you may again appear before
My lord, my
that
lord,
direction,
my lord. Then, my lord, could it be, my lord, on 23rd?
whether you have appeared or not, that is also relevant.
My lord, if the
No, that
yes,
for
ma'am.
that you will have to file an affidavit.
I will. The compliance of the order has to
The
be.
petitioner may file an affidavit within
my lord, 10 days, my lord.
within 10 days from the date of
10
this,
or, my lord,
within 15 days
my,
from the date of this order. However, in the meanwhile, the petitioners, both the petitioners are again directed to appear before the
my lord, I have again confirmed, my lord, Mr. Gautam Bora, he had taken this, the accused to the.
file an affidavit.
I
to
will,
that.
I
Shall again appear before the investigating officer within 15 days, within a week,
will.
within a week from the date of this order. Stop. Send back the case diary to be produced again on after 15 days,
On my lord. On 13th of December.
because this has to be disposed of. It is
Yes.
very not 13, within this
My lord, the week from 20th
last
November, last week I had some.
24th,
24th, my lord.
24 November.
At
The interim
24
order shall
November,
continue till the
My lord, this is in item number 13.
So this is
In
the
item
bonus.
number 14, I had already. Item 14 also ekita. Monsoor.
Oh, same note.
Same.
Same note.
Well, put the application number of the certified of the photocopy of the certified copy be noted, man. Because if it goes back to the police station, this photocopy may not be available again. Because I have this application number, my lord.
I will point- I will point out-
550295.
I will point out the.
flag
copy.
it. Mosumi.
Because if this is the same photocopy, it would show, my lord, that I had appeared. Otherwise, they would not have got this copy.
Same photocopy, they may also collect.
Application number.
Oh, application number.
Number will be the same. Yes, my lord, this is the same. This application number 550295. This is a certified copy application number. It cannot be different if we have not produced.
Before on perusal of the case diary, it appears that
No, they may produce that certified copy through another person also, my lord.
this may
Without my lord himself. going to the
may
police station.
it appears that there is a photocopy of the
Certified.
certified copy of the order dated 23/11/2022 passed by this court. How will we find out
With
whether
application number
the application number
550
550
295,
295
which was made ready on 25/11
which was made ready on
11/20.
25/22 and which was obtained by the present petitioner.
My
Let this case be again fixed on
24.
24th. Next item, same order, name of the petitioner will be.
But my lord, the certified copy of that application will be different, my lord, because this was granted much earlier in point of time. Mansoor, my lord,
Next order, that last certified copy portion is not
That copy is not available. in
not
the case.
necessary.
my lord, this one was on 8 August 22. 8 August 22, on the first
The-
day, my lord. It was
The interim order.
interim.
In second order, the order of the interim order, instead of 23/11, it would be 8/8/22. 20.
And my lord, the allegation, my lord, insofar what I remember from my learned friend pointing out that Iftikar has not appeared. The Pradhan Ayukt or something like that. The IOs.
No, on that aspect, we are,
My lord.
One
Not
more-
only Iftikar, everyone's name is.
one more aspect, one more line should be added. The forensic report has, the copy of forensic report has been also, has also been produced by the learned additional public prosecutor along with the case that I have gone through the content of the forensic report.
Deeply applied.
I'm taking 2 minutes break.
Last chance may be given, Malad. If not, Malad, I am writing, Malad. Then Malad may discuss, Malad. Within 2-3 weeks may be given, Malad, because Hailakandi, Kasar, Hailakandi, you find some difficult, Malad. CB are not regularly coming, Malad.
No, but
Not in this
1
case.
year is too much.
Yes, Malad. Interim issued on 23rd of January.
23rd January interim. And there is no ingredient shortship of the 76 is shortship from the face of the shortship FIR. FIR is bench given.
No information also given that why she did not receive.
Then we are making this that you have appeared before
Iola.
When?
Shortship he appeared on 28th January.
Mr. A.M.S. Gupta, learned counsel for petition. Also heard Mr. K.K. Parasha, learned additional public prosecutor, submits that though the case diary was called for in connection with this case, however, same has not yet arrived. And no cause has been shown by the investigating officer for not sending the case.
On 8 times we have sent malad requisition malad.
Learned counsel for the learned additional public prosecutor also submits that on 8 occasion requisition for the case diary was sent. However, in vain. Stop. On the other hand, it appears from record that on 23/1/2023, the present petitioner, namely Kamran Ahmed, was allowed to go on interim anticipatory bail by this court. Learned counsel for the petitioner submits that after obtaining interim anticipatory bail, the petitioner has appeared before the investigating officer of Kalayan PS case number 310/2022 on 28th January 2023 and has cooperated in the investigation. Stop. Considering the fact that this case has been pending since last 11 months and the prosecution side has failed to produce the case diary even after sending requisition on 8 occasions for the same, and also considering the fact that the petitioner has cooperated in the investigation, the interim anticipatory bail granted to the present petitioner by order dated 23/1/23 is hereby made absolute, subject to the condition that the petitioner shall not directly or indirectly make any inducement, threat, or promise to the first informant / victim or to any person who is acquainted with the facts of this case, so as to dissuade such persons from disclosing such facts to the investigating officer. So, number two, that he shall cooperate in the investigation of the case. With above observation, this will be better.
I know that.
Eighteen also malad CD not received.
I am on interim bail, my lord. Your lordship kindly go to the FIR, my lord. There is a love affair between the boy and girl.
Interim bail since
my lord, long back, my lord. I was granted, my lord, on. No,
1st of March.
yes, sir.
These are all repeated dates are given.
Malad,
Requisition.
some malad,
That
yes, malad,
that
some we have-
only indicates that his custodial detention is not necessary.
Some yes, malad, we have difficulty. Malad. Yes, malad, we have to admit, malad. So Kasar Kamji Halakandi is
Lakhimpur side. Dhubri side.
Because if we now summon the IO before the court, it will take 3 days. It will cause huge loss of public time. Otherwise,
Yes, sir. One thing is happened in this case, my lord. Earlier, it was registered as a Gerupamuk PS case number.
okay.
And thereafter, it was transferred to the Gogamuk PS case number.
Oh, it is Genagamuk no nagi.
The Gogamuk.
Gogamuk.
Thereafter, what happened, my lord? And this honorable court has extended the time to appear before the court. I think they have appeared, my lord. What happened? Another thing has been developed, my lord. The wrong instruction has been come, stated that charge sheet has been filed. Then, my lord, your lordship will file to miss case, my lord. Then thereafter, what happened, my lord? We go to appear before the court, my lord. Then they said that charge sheet was not filed. Then again, my lord, restored the interim order, my lord. Honorable Justice. If your lordship go to the my lord, IA Criminal 495, 2025 3, my lord. If your lordship go to the order, my lord, everything will be, my lord, clear, my lord.
395, no?
Now, whether have you appeared before the IO?
As per my, I have to take my lord because they have appeared, my lord, in Gogamuk, my lord.
Then we will.
Gogamuk that case
Yes.
will be verified, my lord.
They appeared, my lord.
Gogamuk, it's not.
Gogamuk to itu case number to correct question of order to itu.
Gogamuk, 10 oblique 20.
1023. I don't know. No, Gerugamuk 1023. Full level.
Yes, Mr. Parashar, what is your submission?
Gogamuk 37.
Then Gogamuk 3723 that
Maybe otherwise, my lord, there is a decision of the apex criminal. This case is squarely covered. The lord sir kindly go to the my lord. Apex no, my lord. Bombay High Court.
once my lord that Gogamuk
What it says, Bombay High Court?
Bombay High Court said, my lord, there is a love affair between boy and girl, my lord. They might have been together. One thing is, my lord, here, my lord, that they have given, I have given some tablet, my lord. That was also mentioned, my lord. What dead, what not dead.
No,
not
no.
mentioned.
Now we will not go into the merit.
Yes, my lord.
Only fact is that
Yes,
have
my
you
lord.
cooperated in
Yes, my lord. I
investigation?
have cooperated with the investigation, my lord.
but let one instruction be called from Gogamuk because of the because my lord, earlier Gerugamuk just called my lord.
Let us
Subsequently,
give one more chance.
my lord.
Yes, my lord. That is, I myself mentioned these things because he may not be know all these things, my lord.
Heard Mr. NNB Chaudhary, Learned
sir.
Counsel for the petitioner.
Gogamuk, my lord.
Also heard
37
Mr. K.K. Parashar, who submits that though the case diary was called for, however, same has not arrived. London additional public prosecutor submits that he may be given one more chance to seek necessary instructions as well as case diary from the Gogamuk police station to which this case has been transferred. In view of submissions made by Learned Counsel for the Learned Additional Public Prosecutor, the prayer is allowed. Let this case be again fixed on
22nd, 23rd, my lord.
23rd November
No,
for case diary.
Can it be, my lord, 24th, my lord?
24th
24th.
November, 24th November for case diary. The interim order shall continue.
Item number 19,
19 also, my lord, interim, my lord. Since January, my lord.
Interim or correction of 28/4/2023. But he appeared before the IO.
It is not received since 1, 2, 3, 4, 5.
When have you appeared?
As per instruction 30/4/23, after 2 days, he appeared here.
Interim is order issued on the 28th of April. April, no?
Okay, April, yes.
Mr.
Yes.
S. Islam, Learned Counsel for the petitioner, also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor, who submits that though the case diary was called for, however, same has not yet been received, and no intimation
5 times full of liquid.
no intimation has been submitted, has been forwarded by the investigating officer for not sending the case diary. It is also submitted by the additional public prosecutor that on last 5 occasions, requisition was sent for the case diary, but in vain. On the other hand, learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 28/4/2023, and thereafter, in pursuant to the directions of this court, the petitioner, what is the name?
Abu Sayyid
Abu
Riazul Haq.
Riyazul Haq.
Petitioner Abu Sayyid Riazul Haq has appeared before the investigating officer on 30th of April 2023 and has cooperated in investigation. Stop. It appears that this anticipatory bail application is pending since last April 2023. And in spite of several requisitions, the prosecution side has failed to produce the case diary. It also appears that the petitioner has cooperated in the It also appears from the submissions of learned counsel for the petitioner that the petitioner has cooperated in the investigation. In view of above, the interim anticipatory bail granted to the petitioner Abu Sayyid Riazul Haq on 28/4/2023 is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is closed.
Item 20,
Matlab 20
My
matlab
lord, I am in interim bail since 17/5/2023, my lord. And since then it has been pending before
15/5
15/5, and my statement was recorded on
matlab
17th.
here matlab alias D was available. Twice matlab what matlab injury DNA test report was not available matlab because of that up to date CD was called for along with the DNA report matlab. But that up to date CD along with the DNA report is not available today matlab. Alias CD was available matlab. On
My lord, I am physically disabled person. And with that effect, I have filed one IA.
Otherwise, whether he has appeared before the IO,
It's my lord.
that it is not written in the matlab.
whether you can seek instruction over telephone.
Matlab yes.
You just seek that instruction, whether he has appeared.
Yes, my lord, I have appeared on 17/5/2023.
Then
After
at 2 p.m., we will
Hello.
pass on. Let him also verify.
my lord.
If he has appeared, we will dispose the topic.
item number 21,
May I take up? The petitioner is in interim, my lord, since 9/6/23, my lord. My lord, your lordships can be perused the order dated 38/2023, my lord, last two paragraphs.
Here also matlab
Lordships will satisfy to
CD
absolute
return for updation matlab DNA
my lord.
DNA report was not
The
available.
petitioner have already, my lord, given the blood, my lord.
You have cooperated.
My lord, my
Blood
lord.
sample you have.
Yes, we have already, the petitioner have already given the blood sample. Police are taken due process, my lord. Due process of law.
Okay.
Yes, my.
376
Therefore,
matlab.
absolute, my lord, if the DNA report received by the police will submit the search sheet, my lord, petitioner will face the trial if there is any matching, my lord. Interim order may be absolute, I claim.
Otherwise matlab CD was earlier available. Up to date CD was called for along with DNA report matlab. DNA was sent for FSL matlab, but FSL report is not available today along with CD.
Now, what will happen if DNA is positive? Now, what-
Matlab these are matlab not DA matlab the anticipatory bail matlab.
Custodial interrogation that
Because he will have to face trial on.
yes, my lord.
That is there matlab, but
because in anticipatory bail application, we are concerned about his requirement for custodial interrogation. Heard
TSK, my lord.
Mr. T. Sheikh,
Yes.
learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, who submits that the up-to-date case diary along with DNA report has not yet been received as was called for by this court. Why it has not been sent, any
No, my lord, that understanding.
no reason has been mentioned as to why the report has not been furnished. Stuff. On the other hand, Mr. T. Sheikh, learned counsel for the petitioner, submits that the petitioner was granted interim anticipatory bail by order dated
9/6/20.
9/6/2023, and you have appeared before, your statement was recorded.
Yes, my lord.
And he has
Appeared, my-
appeared before the learned trial court in pursuant to the direction of this court, and his statement was also recorded. He has also submitted that the petitioner has also cooperated with the investigating officer by allowing the investigating officer to collect the blood sample of the petitioner for DNA examination. It is further submitted that considering the conduct of the present petitioner in showing cooperation in the investigation, his custodial detention may not be necessary. Stop. After considering the submissions made by counsel for the petitioner, it appears that the petitioner is cooperating in the investigation and has complied with the order dated and have complied with the conditions of interim anticipatory bail order granted to him. In view of above, the interim anticipatory bail granted to the present petitioner by order dated 9/6/2023 is hereby made absolute with condition numbers 2, 3, and 4 attached to the said order remaining intact. With above observation, this bail application, anticipatory bail application is thereby disposed of.
Item
Congrats, ma'am.
22,
22 my lord, charge sheet submitted.
Even your lordship.
At CS number 82/23.
You were on
Interim,
interim bail.
interim, your
Have
lordship.
you appeared?
No, your lordship.
No, after interim bail,
What happened, your lordship? When the petitioner came for getting the interim order from the route, he was missing, your lordship. Till date, he is not found.
who is missing? Petitioner is,
Petitioner.
okay, then we will dispose of this application. Heard
A Begum.
Ms. A. Begum, learned counsel for the petitioner, also heard Mr. K. K. Parashar, learned additional public prosecutor. Mr. Learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet, white charge sheet number.
82/23 dated 3/07/23.
Stop. On the other hand, learned counsel for the petitioner has submitted that after obtaining the interim anticipatory bail order, the petitioner went missing and he has not appeared before the investigating officer. In view of the submission made by learned counsel for the petitioner, the interim anticipatory bail application is interim anticipatory bail granted to the petitioner by order dated 26/2023 is hereby vacated and this bail application is dismissed.
Item 23,
23 my lord, CD and injury report not received, my lord. Though he is in interim, my lord, since 24th of August, my lord, but Section 326 is the injury report is necessary, my lord.
Let
As
it-
per the FIR, Lordship, and otherwise.
Let us give one, let us see. How Mr. F. Hawk, learned counsel for the petitioner, also heard Mr. K. Parashar, learned additional public prosecutor, who submits that, who prays for another date for producing the case that the prayer is allowed. Let this case be fixed again on
24th of November.
24 November. The interim order shall continue till next day.
Obliged.
24.
Yeah, also, my lord, CD and PM report is not available, my lord.
Whether petitioner is not interim matter, and whether
Not on interim.
not, and whether this is a case of suicide matter. And the husband, my lord, who is supposed to be the husband, my lord, he was in judicial custody. And petitioner before lordship is my lord, mother and father of the
Mother and father, let them appear before the IO. The petition, the husband has been arrested.
arrested. He is judicial, my lord, he is a minor matter.
Husband is minor.
Minor. The victim is major, my lord, husband is minor. He is in my lord,
Okay. Heard, Mr. This is for which time the CD has not yet.
this is a third time. Third time.
No,
This was the second, the third.
Three.
fourth time.
Heard, Mr. A. Conicot, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, the investigating officer has not punished the same, and no cause has been shown for not punishing the case diary. Stop. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Mohan Dole and Srimati Jyotirekha Dole, who are apprehending their arrest in connection with Dhokwakhana PS case number 97/2023 under section 120B/498/498A/302 of the Indian Penal Code. The gist of accusation in this case is that on 28/7/2023, one Srimati Smita Pegu lodged an FIR before the officer in charge of Dhokwakhana police station, inter alia, alleging that on 12/12/2023,
It should be 22, my lord, not 23.
12/12/2022. The date of FIR is also 22.
Madam, date of birth, madam, this is a date of marriage. 12/20.
Okay, date of FIR is okay, 23.
Then
That on 12/12/23, 22, the daughter of the first informant was married to the accused number one named in the FIR, namely Prabhan Dole, who is the son of the present petitioners, and
on 28/7.
on 28/7/2023, it was in the informant came to know that her daughter has committed suicide in her husband's house. Stop. It is alleged in the FIR that the accused persons named in the FIR had killed the daughter of the first informant. Stop. Learned counsel for the petitioner submits that the main accused, that is the son of the present petitioners, has already been arrested, and he is detained behind the bar. And it is further submitted that the present petitioners are no way involved in the offense alleged in the FIR. It is further submitted by learned counsel for the petitioner that the petitioners are ready to cooperate with the investigating officer. So, in view of the fact that the prosecution side has failed to produce the case diary even on the fourth occasion, also in view of the fact that the main accused of the case has already been detained behind the bar and present petitioners who are the in-laws of the deceased are ready to cooperate with the ready to cooperate in the investigation, comma, the above named petitioners, the petitioners, namely
Mohan
Mohan Dole and Srimati Jyotirekha Dole are hereby directed to appear before the investigating officer of Dhokwakhana PS case number 97/23 within 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, comma, in the event of their arrest in connection with Dhokwakhana PS case number 97/23, they shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that they shall cooperate in the investigation. With above observation, this anticipatory bail application is hereby dismissed.
Develop.
Item 26.
Very please, your lordship. 438 application matter. FIR at page 17, my lord. The prime accused he was arrested and released on bail matter. Let the petitioner number one, accused number one in the FIR and the informant are neighbors, my lord. One is the adjacent to other. And there was some quarrel, my lord, for a common violence. And the informant, the accused number one, my lord, he is not the petitioner. He boarded some stones in the roadside, my lord. And for boarding some stones, and they face some problem for ingress and egress. Therefore, there are some alterations there. Some push and pull was there, my lord. But section 380 and 354 does not attack. Some quarrel is there, my lord, between the two families.
It is there.
It is there, not injury report is there. Or the victim got injured by bite mark is also there in her body. Not fit for full respect, I submit. Anticipatory bail.
The petitioner number one, he is the prime accused. He is there. He is in jail. He is arrested. Otherwise,
Petitioner number one.
Accused number one, he is in jail and he is released also. We are for other.
And his name has to be deleted.
No,
Accused number one,
Accused number one
Maharoom
is not
Ali.
the petitioner.
Maharoom Ali.
Who suffered the injury?
This lady informant.
What is her statement? Who bite her?
Yes, sir. And eyewitnesses are also there to the occurrence. The injury report is marked as MR, medical report. That is victim statement. No? And subsequently, there are eyewitnesses also.
Who is the petitioner? What is the name?
Petitioner, there are
Five numbers of
six
petitioners.
petitioners. They are all named.
Shahidul is also one of the petitioners.
No,
They are.
No, ma'am.
Sahidul is here, not there.
Shahidul is the accused number 1 in the FIR.
And Mohrum? Mohrum?
Morum is,
Morum
my
is
lord, in
there.
the typing, in the typeface, my lord, is some wrong, my lord. One, the accused number 1, his name is not written, my lord. Otherwise, Shahidul Islam is the accused number 1. And Mohorum is the accused number 2, my.
Main
And-
allegation are against both of them, Shahidul and Mohrum.
Maybe all are not.
They are not the petitioner.
Shahidul is arrested. Mohorum is the petitioner.
Mohrum is the
Is the-
Siraj, Mufidul, they are all named, you know.
Right.
They all attacked.
Mohorum Ali, Idris Ali, Agnur Ali,
Idris Ali also, you know.
Samsul Ali, Mofidul Ali, and Siraj Ali. These are the petitioners.
Where is the bail order of main accused?
My lord, he's in jail, man.
Or
He is
he
released from the trial. My lord. That order is not.
After regular case. But this is with all respect, I submit this is a crime against a woman, not anticipatory bail. You know, I have objection to that.
no, why Shahidul was released?
My lord, on the next day, my lord, Shahidul was arrested.
Why he was released? On what ground?
My lord, he was arrested. Most probably he is released on default bail, my lord, because 90 days already.
Okay.
Medical report is there.
Okay, there are serious allegations against Mahrum. He may not be granted. As regards others, they will appear before. Right. Third, Mr.
Yeah.
Third, Mr. A.K. Azad, learned counsel for the petitioner. This application under also heard Mr. T. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the 6 numbers of petitioners, namely 1. Mahroom Ali, number 2. Idris Ali, number 3. Aznur Ali, 4. Samsul Ali, 5. Mofidul Ali, 6. And 6. Siraj Ali, who are apprehending their arrest in connection with Goresh PS case number 124/2023 under section 448/326/427/354/34 of the Indian Penal Code. The gist of accusation in this case is that on 7/7/2023, the victim of this case lodged an FIR before the officer in charge of Goreshar Police Station, inter alia, alleging that the accused persons named in the FIR within bracket 7 number named in the FIR, trespassed into her house and started breaking the glasses of windows and other articles. And when the informant protested, the accused Shahidul and Mohroom assaulted the father of the first informant and also assaulted the first informant and tried to outrage her modesty. Stop. Learned counsel for the petitioner submit that the main accused in this case, namely Shahidul, was arrested, and after completion of statutory period of detention, he was allowed to go on bail. Learned counsel for the petitioner has also submitted that the allegations leveled in the FIR against the present petitioners are not true, and they are not involved in the alleged offence in any manner. On the other hand, Mr. D. Das, learned additional public prosecutor, has produced the case diary of Goresh PS case number 124/23, and has vehemently opposed the grant of bail to the present petitioner on the ground that there are incriminating materials against the present petitioner, and the offence involved an offence against women. Stop. I have considered the submissions made by learned counsel for both the sides, and have perused the case diary of Goresh PS case number 124/2023. It appears from the case diary that the main accused Shahidul Islam or what?
Shahidul Ali, man.
Shahidul Ali has already been arrested. It also appears from the case diary that there are serious incriminating material against petitioner Mahroom Ali in the case diary, including the statement of the victim recorded by the IO, which does not justify his release on anticipatory bail at this stage of investigation. So, hence, the prayer for grant of anticipatory bail to the accused Mahroom Ali is hereby rejected. However, as regards other accused persons, namely Idris Ali, Aznur Ali, Samsul Ali, Mafidul Ali, and Chiraj Ali, there is no specific allegation against them, and a general allegation is made against them that they trespassed into the house of the victim girl. Considering the materials in the case diary, as well as submissions made by the counsel for both sides, I am of the considered opinion that as regards petitioner number 2 to 6, their custodial detention may not be necessary for fair completion of the investigation if they cooperate with the investigating officer. So hence, the petitioners, namely Idris Ali, Aznur Ali, Samsul Ali, Mafidul, and Firazul Ali, are hereby directed to appear before the investigating officer of Goresh PS case number 124/23 within a period of 10 days from the date of this order. Stop. And if they do so within the stipulated period of time, in the event of their arrest in connection with Goresh PS case number 124/23, they shall be allowed to go on bail of 30,000 each, with one surety of like amount, subject to the satisfaction of arresting authority with following conditions. Number 1, they shall cooperate with the investigating officer in fair investigation of the case. Number 2, they shall not directly or indirectly make any inducement, threat, or promise to the victim girl or to any person who is acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the investigating officer or before the court. With above observation, the anticipatory bail application is thereby send back case diary.
Highly obliged.
27.
27, no, I'm sorry, case diary is not there. No. He is on interim, I think.
Heard Miss
Pico.
T. Ghosh, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who submits that he may be allowed some more time to produce the case diary. The prayer is allowed. Let this case be fixed again on
29th of November.
29th of November. The interim order shall continue.
Item 28,
My lord,
Similar prayer, my lord. Case diary is not there. He is on interim.
Same order, same
Same
counsel.
order.
item 29,
Wait, on a pre-arrest bail application, my information goes that charge sheet has been filed.
Yes, that is it. No?
Charge sheet filed, my lord, interim was provided on 29/23.
You appeared before the IO.
My lord, I appeared before that. So, my lord,
Heard Mr. P. K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has laid the charge sheet, white charge sheet number
297/23.
dated
297/23 dated 11/9/23.
learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court by order dated 29/2023. And in pursuant to the direction of this court, the petitioner has appeared before the investigating officer and has cooperated with him in the investigation. Stop. In view of submissions made by learned counsel for the petitioner, this anticipatory bail is disposed of by making the interim anticipatory bail granted to the petitioner by order dated 29/2023 absolute, with condition number 1 and 2 attached to the said order remaining intact. With above observation, this bail application is disposed.
can I make one small prayer, my lord? Item number 35, case diary is not listed. I am on interim. Can we, my lord? Item 35,
35.
case diary not listed.
Jumping the queue.
No, jumping the queue, my lord, some liberty.
Heard Mr. P. K. Roy Chaudhary.
He is there.
No, I am appealing for the informant. We have already filed our wakalatnama and objection yesterday.
Case diary has not listed.
Case diary is not.
Also heard Mr. D. Das, learned counsel for the learned additional public prosecutor, as well as Mr. A. Ganguly, who appears for the informant. You will be filing objection,
We have already filed yesterday.
who submits that he has already filed the objection against the prayer for bail to the petitioner. Learned additional public prosecutor prays for another date for producing the case that prayer is allowed. Let this case be fixed again on
On 29/11.
29/11. The name of the counsel for the counsel for the informant shall be shown in the cause list henceforth. Let this case be fixed on 29/11. The interim order shall continue.
Obliged. I am
Item-
highly obliged.
30,
So for item number 30 is concerned, my lord, earlier perhaps we produced the case diary, but I was directed to return the case diary for getting it updated, my lord. Now we sent it back, my lord, updated case diary is not received. Hmm?
You are on interim bail. Petitioner is on bail.
No, my lord, no interim.
Yeah, full thana.
My lord, petition number 4 is a lady, my lord.
My lord, let a short date be fixed, my lord,
Shorted.
on 21. On 21, my lord.
Heard Mr.
MM Zaman.
N.M. Zaman, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who prays for another date for producing the case that the prayer is allowed. Let this case be listed again on
On 22nd.
22nd November.
Can it be on 14?
No, it is from proprietor.
17th, because there is no interim order.
Will it be possible?
Let it be 20 Monday.
On 20th of November 2000.
Item 31,
31 case there is there.
Yeah, please, Your Lordship. For a case application, my lord, I am on interim.
The petitioner has appeared before the IO and he has cooperated. He is on interim, I think, and he has cooperated with the investigation.
Third, Mr. D. Bora, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor, who has produced the case diary of Laluk Police Station case number 177/2023. Stop. Learned counsel for the learned additional public prosecutor has submitted that the petitioner has appeared before the investigating officer and has cooperated in the investigation. So it appears from record that the petitioner was earlier granted interim anticipatory bail by order dated 21/9/2023. And from the submission of learned additional public prosecutor, it appears that the petitioner is cooperating in the investigation. In view of above, the anticipatory order, bail order dated 21/9/2023, whereby the petitioner was 21/9/2023 is hereby made absolute, subject to the condition that the petitioner shall continue to cooperate with the investigation, in the investigation.
Deeply object.
Bail application is thereby disposed of.
32,
May please, Your Lordship.
My lord, here, my lord, he is on interim, my lord, case there is not received.
Heard Mr. S. Das. This is the first date.
First day.
Heard Mr. S. Das. Learned counsel for the petitioner. Also heard Mr. E. Das, learned additional public prosecutor, who prays for another date for producing the case that the prayer is allowed. Let this matter be listed again on
30/11.
30/11. The interim order shall continue till next.
Highly obliged.
item 33,
33 case there is there, my lord.
I am on interim matter. I have appeared.
My lord, yes, he is. He has appeared, my lord. He is an employee of DSR, my lord. Actually, after he married this informant, my lord, initially it was lost complaint case, thereafter it was registered as clear case. But he married in 2019, in spite of having his first wife.
But
And
he is
thereafter
cooperating.
Now he is cooperating.
Heard.
And in fact, my lord, there is a settlement.
Okay.
A settlement has been made outside the court.
Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, who has produced the case diary of Dudnoi PS case number 62/2023 and has submitted that the petitioner, who was on interim bail, has cooperated with in the investigation, and his statements under section 161 has already been 161 of the Code of Criminal Procedure has already been recorded by the investigating officer. Stop. In view of the fact that the petitioner has complied with the direction of this court, the interim anticipatory bail granted to the present petitioner by order dated 29/9/2023 is hereby made absolute, with condition number 2 and 3 attached to the said order remaining intact. With above observation, this anticipatory bail application is thereby
Obliged.
34,
Deeply obliged.
Party from the charge sheet submitted.
No interim.
What is the offense?
376 1 my lord. 09506. CS number 426/23 dated 10/10/20.
You appear before the trial court. Heard. This is 34.
Four.
Heard Miss M.N.M. Deka, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that though the charge sheet was called for in this case, however, in the meanwhile, the investigating officer has though the case diary was called for in this case, however, in the meanwhile, investigating officer has laid the charge sheet, white charge sheet number
426/23 dated 10/10/20.
stop. In view of the laying of charge sheet in this case, this bail, anticipatory bail application is hereby disposed of with an observation that the petitioner may approach the trial court and may pray for regular bail before learned trial court if so advised.
item 36,
Wait, please hold on. My lord, this is a 438 application, my lord. FIR, my lord, is at page number 21. Basically, my lord, the allegation in the FIR is that the petitioner, my lord, was a secretary of the modus operandi Homobai Homiti, my lord. One Ayub Ali, who was a contested in an election, my lord, which was cancelled, and where, my lord, the petitioner was a signatory, my lord. He lodged an FIR alleging that, my lord, the petitioner was habitually stealing and selling subsidized rice from the Homobai Homiti, my lord. But, my lord, after going through the record, my lord was pleased to grant interim, my lord. He appeared before the IO and he has cooperated with the investigation.
Cooperating, my lord. Statement recorded, my lord.
Only one bag rice was
One bag.
One big right.
heard. Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that the charge sheet that
Appeared, my lord. Statement
the
recorded.
petitioner was granted interim anticipatory bail by this court by order dated 6/10/2023, and he has appeared before the investigating officer and has cooperated in the investigation, and his statement under section 161 CRPC has also been recorded. Stop. In view of the fact that the petitioner has complied with the direction of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner, namely Ataur Rahman, by order dated 6/10/2023, is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. With above observation, this anticipatory bail application.
Highly obliged.
item 37 along with item 56.
The application. The application for 38 lordship. Delegation lordship 326, 342, and 34 lordship. FIR lordship at 8 lordship.
Yes, let us go through the FIR first. FIR is at page
8 lordships.
what is the injury?
Well, injury report is not available, but one CT scan report is available. And as far as pair of the IO, Subsequently, 120B, 353, 354 and 307 was added. Subsequently, earlier 326 and 342, 307 was added. Only CT scan report of tissue injury are salon in the left frontal region. And that is there. And as per the statement of the eyewitness and the statement of the injured he was mercilessly beaten by several people, and there are 3 eyewitness who took the name of in this petition there are 7 petitioner in both the petition out of 7 5% has been implicated by the eyewitness.
Who have been implicated?
Eyewitnesses in item number
We are now taking up 37.
37 37 Sahadat Ali, petition number 1 and 3,
Shahadat Ali and
and Abdullah and Aslab, their name was not taken by the eyewitness.
only Shahadat Ali's name.
Sahadat and Jawahar Ali, petition number 3. They beat them.
Not only to save his skill lordship, he has lost the FIR lordship, all the villagers lordship held a meeting. In that meeting lordship, some resolution was taken, that is your lordship will find it case 14. What type of person lordship he is, that is reflected lordship is. Your lordship may kindly come
At
with
two. At 2.
bearing matter.
Heard, Mr.
Yeah, I'm also respondent number 1,
What is your name?
FK Ahmed.
Heard, Mr. F.K.R. Ahmed, Senate Council for respondent number 1, who submits that his Senate Council,
Often called my lordship.
you are suffering, that he is indisposed. On that ground, he prays for an adjournment. Also heard Mr. B.C. Dar. You are appearing for
Petitioner.
Senate Council for the petitioner who does not oppose the prayer for adjournment, considering the grounds stated by the respondent's counsel. Stop. The prayer is allowed. Let this matter be listed on
After a week, my lord.
after
15 or 16th of the next week, The 2 cases are may not stay, proceeding further proceeding stay. So it should be little bit 15 or 16th
on
of
15th of November.
Right.
All right.
Yeah, your lordship has already gone to the FIR, that is page 8. Your lordship may kindly come to page 14. This is the resolution adopted by the villager against that person. Page 15 is the relevant.
No, I forgot the,
My lord,
what was the,
page 8 is the FIR.
yes,
May I read?
no, you can tell me the gist,
My lord,
or you may read out.
short 8 is that there is allegation is that here the victim informant was assaulted by the villager. My lord, in fact, lordship, he while he was doing some,
What is your name?
my lord,
Shahadat.
we are lordship, 4 lordship,
Shahadat.
all the FIR.
All the FI names.
All the
My lord, all the family. We are the villagers lordship. In fact, lordship, the informant, while he was caught in red-handed lordship in doing some illegal activities, the villager came and the lordship, yes, it was a repeated that some altercation took place. And lordship, to that effect, the villager held a meeting lordship, that is, the lordship kindly come to page 15.
No, but we are concerned with the allegation of assault.
My lord.
Injury report, that informant is not available, but here only CT scan report is available, and on the pair of the IO, subsequently 120B, 353, 354, and 307 were added in this case. So, but eyewitness
64 eyewitness is available along with the statement of the injury, that informant. He was assaulted by several people, but eyewitness took the name of not all, in item 37,
Shahadat Ali.
Shahadat and Zahar. One witness stated that I have not seen Abdullah.
Okay.
Other Aslab Hussain, this name not came, Aslab Hussain, son of Dildar. Another.
What is the injury caused? Without injury report, can it be?
That is there, because 307 is added, so injury report is not available.
Yeah.
No, but there is something to indicate that
Yeah.
he sustained injuries on head.
CT scan of brain, one CT scan report is available here. Soft tissue injuries salon in left parental region. So he was beaten, as per the statement of eyewitness also, he was beaten by wooden thing in forehead. That is the statement of the eyewitness, and other also mercilessly beaten, but other bodily injury is not available.
Medical injury, Lordship, that may be simple in nature. Because, yes, admittedly, some altercation took place, because he was.
No, mere CT scan of brain, that CT scan was performed in itself does not make an injury trivial. Now, whether the injury was simple or trivial.
And that report is not available. That is the.
What is your submission?
Otherwise, one petitioner, as per the statement of the two eyewitness, that one.
No, is there anything to indicate the condition of the victim? Whether he, from the statement.
From his statement, I'm right. So অৱস্থাত যাই মোক ঘৰৰ ভিতৰত সোমাই দি মানে কেইজনমান লোকে মোক লোহাৰ ৰড বাঁহৰ লাঠি আদিৰে মাৰপিট কৰে আৰু মূৰত মাৰপিট কৰি গুৰুতৰভাৱে জখম কৰে। So as per the statement of the victim, informant, গুৰুতৰভাৱে জখম কৰে। So I need the
that is the allegation in the FIR.
Police subsequently rescued them as per the statement of the eyewitness also.
He was handed over to the police.
Yes, what is your submission?
One person in item number 56, petitioner number 1, Rafizul Ali, Rafizul Islam. He hit by one iron rod, as per the statement of the eyewitness. Other Sahadat Hakimuddin Sheikh and Sahadat Ali, son of Sajiuddin and Zaharuddin. These persons are named by the eyewitnesses. Abdullah and Aslab Hussain, these names are not taken by the eyewitnesses.
No,
So
Shahadat and Jahar, what weapon they used?
They by wooden bamboo stick, others by bamboo sticks, and only that Rafizul Ali, alias Rafizul Islam, he used iron rod.
Item number 37.
Petitioner in other case.
Item number 37, as per the statement, petition number 1 and 3 are implicated. 2 and 4 are not implicated by the eyewitnesses.
So what is your submission?
I have objection against those persons who have been implicated by the eyewitnesses.
What is your submission?
My lord, so far his statement itself is concerned, they were not by any armed or any lordship dangerous.
Except Rafizul, others. Rafizul used iron rod.
Yes.
Heard Mr. M. Khan. In item number 37. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section Mosumi. 350, we will write that 350. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by phone number of petitioners, namely Sahadat Ali, Abdullah, Johar Ali, Aslap Hussain, Ilyas Aslap Ali, who are apprehending their arrest in connection with Manikpur TS case number 175/2023 under section 326/342/34 of the Indian Penal Code. The accusation in this case is that on 25/9/2023, one Mohammad Sorhab Ali lodged an FIR before the in charge of Gerukabari Police Station, inter alia, alleging that on 24/9/2023 at about 7 p.m., the accused persons named in the FIR within bracket present petitioners trespassed into the house of the informant and assaulted him with iron rod, bamboo stick, and other bamboo stick, and caused serious injury on his person. No, these two relates to same offense.
Same incident.
Same incident.
So only 4 are named. Then why this
My-
second
in-
page?
In fact, Lordship, large number of people were gathered.
But in the FIR,
FIR named only four.
4. So all 4 are in the first petition.
Yes.
Yes.
In second petition,
Is
they are not named in the.
Not that.
they are not.
And Malat, another thing, Malat, there is a statement of one ASI also, Malat, when they went to rescue the person, Malat, this person, Malat, Hakimuddin Sahadat Johar, they also, Malat, amak tanatani kori, amak sorkari kamat badha arop korisil. So, Malat, they are, Malat, Malat, this person, Malat, who has, Malat, refusal, Johar and Hakimuddin. Refusal name also taken by the police ASI also.
Custodial interrogation in this case. But that may be
Taking the law in their hand, something may happen, illegal is going on.
Learned counsel for the petitioner has submit. What is your submission?
My lord, you Lordship, my lord, in fact, Lordship, the informant Lordship, he was involved in various unsocial activities, Lordship.
That the informant was found indulging in immoral activities, and therefore he was beaten up
He
by,
was caught in red-handed.
he was caught red-handed and beaten up by the villagers. And whether present petitioners also beat him up,
No, Lordship, they were there, but so far,
it is also submitted by the learned counsel for the petitioner that though the petitioners were present at the place of incident, however, they did not assaulted the first informant. On the other hand, learned additional public prosecutor has produced the case diary of the
Manikpur PS case number
Manipur case case number
175.
175/23 and has submitted that there are materials in the case diary against the accused Shahadat Ali and Johar Ali, and witnesses have deposed that both of them have assaulted the informant with bamboo sticks. On the other hand, learned additional public prosecutor has fairly submitted that at the present stage of investigation, there is no material against the petitioner Abdullah and Aslaf Ali. Learned additional public prosecutor has also submitted that the injury report is not available, though a medical document is there in the case diary to suggest that the first informant was
Suffered by head injury, my lord.
was
Suffered by
that the a CT scan was performed on the first informant, where it found that he sustained head injury. But the nature of head injury is also that only soft tissue,
soft tissue frontal on soft tissue left frontal region.
internally or external.
That is not.
Now, should we ask for the injury report or
That
should we
is,
allow?
Malad, because Malad, the ASI also stated that Robert Mari Mulfatai dise. That is the version of the ASI.
Okay.
Other also stated that the head injury. So ASI also stated that.
Considering the submissions made by learned counsel, learned additional public prosecutor, it appears that perusal of injury report may be necessary. However, as the hence call for the injury report, fixing, give a date.
Manipur.
We are not in there. Okay.
Give a long date. They will be directed to appear before the IF.
And then Malad 29th of November.
Fixing 29th of November for injury report. In the meanwhile, the petitioners, above named petitioners are hereby directed to appear before the investigating officer of Manikpur PS case number 175/2023 within a period of 10 days from the date of this order. And if they do so within the stipulated period of time, in event of their arrest in connection with Manikpur PS case number 175/23, the above named petitioners shall be allowed to go on interim anticipatory bail of rupees 30,000 each with one surety of like amount, subject to the condition that they shall cooperate with the investigating officer and shall appear before the investigating officer as and when so required by the investigating officer. Number 2, that they shall not directly or indirectly make any inducement, threat or promise to the victim or to any other person who is acquainted with the facts of the case so as to dissuade such person from disclosing such facts to the investigating officer or to the court. Let this matter be listed again on 29/11. In item number 56.
56 Malad, I have objection regarding interim in favor of Malad Rafizul Malad.
Rafizul, we are not giving any protection now. Others, same order.
In the one submission, in the affair, Lordship,
You are not named,
problem, okay.
but case there are
Yes,
many.
And it's specifically mentioned about one accused, Lordship, that
In 50, in item number 56, let me dictate. This is an application under section, no, hard, Mr. What is your name?
J. Abbas. J. Abbas.
J. Abbas, learned counsel for the petitioner, also heard Mr. K. Parashar, learned additional public prosecutor. This is an application under section 438 of the Code of Criminal Procedure, 1973, filed by 3 petitioners, namely Rafizul Ali alias Rafiqul Islam Number two, Sahadat Ali and Hakimuddin Sheikh, who are apprehending their arrest in connection with Manipur PS case number 175/23 under section 326/342/34 of the Indian Penal Code. Gist of accusation same as earlier case. Learned counsel for the petitioner has submitted that the present petitioners are not named in the FIR. Any other submission?
Lordship, one thing Lordship may consider, Lordship, in the affair, the complainant mentioned specifically about accused number 1. I think there is no mention about by the Rafizul, there is no mention about Rafizul Lordship. If
But as per the statement of the ASI also, Rafizul is implicated, that he hit by iron rod.
Learned counsel for the petitioner has also submitted that the the FIR specifically name one Abdullah.
Yeah.
And his another co-accused person. However, it does not name any of the present petitioner. It is also submitted by learned counsel for the petitioner that same submission that the accused was from the earlier case. On the other hand, learned additional public prosecutor has produced the case diary of Manipur PS case number 175/23 and has submitted that though that there are incriminating material against the petitioner Rafizul Ali alias Rafizul Islam of him assaulting the first informant with an iron rod. So, learned additional public prosecutor has also submitted that though a CT scan report is available in the case diary, however, perusal of the injury report would be necessary. We will keep his case pending, Rafizul's case pending. We will not reject it now. We will give interim to others.
Yes, my lord.
No relief to him. After perusal of the injury report, we will stop. Hence, learned counsel for the learned additional public prosecutor submits that perusal of the injury report may be necessary in this case. Hence, call for the injury report, fixing 2911 for injury report. However, in the meanwhile, considering the fact that considering the fact that the materials in the case diary against petitioners Sahadat Ali and Hakimuddin Sheikh are not so serious in nature at this stage of investigation. They are allowed to appear, they are directed to appear before the officer, the investigating officer of Manikpur Police Station case number 175/23 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Manipur Police Station case number 175/2023, they shall be allowed to go on in interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to following same code. Let this case be fixed on 29.
it may be fixed, Lordship, along with that.
Yes,
Item 30.
along with let this case be fixed on 29/11/2023, along with AB case number 3463 of 23.
Apply.
Please, your lordship. Lordship, on the instruction of our client, my lord, we are seeking to withdraw this petition and file a fresh.
Mr.
U. Sharma.
A. Sharma,
My lord, U. Sharma.
you
Yes, ma'am.
heard Mr. U. Sharma, learned counsel for the petitioner, who submits that he has instructions from the petitioner to withdraw the instant criminal petition, criminal revision petition. Stop. Also heard Mr. K.K. Parakar, considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This case is dismissed on withdrawal,
My lord,
with a
liberty may
liberty
be
to file afresh if so required.
obliged.
May I please your lordship? My lord, 439 bail application, my lord. He is in jail for about 3 years, my lord, 1043 days.
3 years.
3 years, my lord. And
NDPS case.
my lord, section is 302. It
302.
was 326, 307.
Killed his wife, my lord.
Huh?
He killed his wife.
This is the allegation, my lord. Kindly turn to FIR, my lord, at page 14.
No, what stage trial is pending?
But trial charge has been framed on 19/1/23, but till date no
Not a
no
single
witness has been
witness
examined.
has
my lord.
turned up. And
No witness has been examined. Other man and at the evidence stage, my lord. Yes.
my lord, one more important point, my lord. Even I am entitled to my lord default bail also, my lord. It is submitted after 90 days, man. It is
No,
a
but have you paid for default bail when it?
my lord, petition is filed. Default word is not used, but petition is filed and rejected. Word is not used. Of course, I checked, my lord, but it is bail is rejected.
Normal bail and due, unless you pray for default bail when it is due.
That extinguished, my lord.
That
That is
extinguishes.
extinguished.
My lord, the petition is there. The word I not used, my lord, that I have checked. Is but the
No, after 3 years, you may otherwise get bail for
yes,
long
my
detention.
for so much long incarceration and without any, my lord.
I leave to your lordship, my lord. He has a daughter also, my lord, minor daughter, and my lord, only almost 3 years, my lord.
It is not a case, my lord. He was arrested, my lord, fast, my lord. He
And,
himself
my lord,
went to the police station.
and I have examined
Himself went to police station to say the real things. Then police accepted, my lord. It is not that he was.
your lordship will kindly see the peruse the 161 statement I have remarked. My lord, there are some witnesses have said, my lord, there was frequent quarrel between husband and wife.
Regarding some extramarital
And
relation.
perhaps, my lord, at the heat of the moment, my lord, he killed. And his statement is also there, my lord. There also he has said, my lord.
Who are the witnesses?
My lord, witnesses, my lord, I do not know them.
Relative witnesses.
No, my lord. No
plus,
relative
I mean,
witnesses.
neighboring people.
Neighbor, my lord. Independent witness, Muslim, my lord.
Then let him face
Occurrence
trial.
took place in the night, my lord. Occurrence
Let him face trial.
Let him face trial, my lord. 3 years already, my lord, he is in. And he surrendered after committing the, my lord, offense. He surrendered before the police. He himself.
Heard Mr.
A.K.
Talukdar, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. His application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Mohammad Mridul Ahmed, who has been detained behind the bar since 30/12/2020. Within bracket. How many days? 2 years, 11 months.
My lord, yes, my lord. So 1043 days. 1043
He
days.
surrendered on 30, on the date of occurrence itself, 30/12/2020. my lord.
Learned,
And on his surrender, my lord, he was arrested. 30/12/2020.
learned counsel for the petitioner submits that the allegation against the
2 years, 11 months.
present petitioner is that he has killed his wife. It is submitted that on the basis of with the said allegations and FIR was lodged before the officer in charge of which Washishta police station. Washishta police station on, where is the FIR?
My lord, is page 14. my lord.
On 31/12/2020.
My
And
lord,
there,
PS case is Hatigao. He went to Basista police. My lord.
on where the FIR was lodged?
Hatigao. Hatigao.
Hatigao police station on 31/12/2020. It is also submitted that after the incident, the petitioner surrendered before Hatigao police station,
Basista PS.
Washishta police station on 30/12/2020. After lodging of the FIR and registration of Hatigao PS case number 798/20 was registered under section 306/307 of the IPC. And later on, after completion of the investigation, charge sheet was laid, white charge sheet number 52/2021, dated 31/3/2021, against the present petitioner under section 302.
My lord, first of it was 326, then 302.
The charge sheet
Added
was,
section 30, only 302.
charge sheet was laid under section 302 of IPC. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar for almost last 3 years, for almost more than 2 years, 11 months.
2 years, 10 months.
2 years, 10 months. 2 years, 10 months. And he is you are the resident of?
Yeah. Resident. He's a tenant,
Resident of my lord, original
Sifajhat.
original address is my lord Sifajhat.
No,
the permanent resident of Border.
how your presence would be certain in Guwahati court?
My lord,
As soon as we release you, you will flee away.
my lord, from the behavior, his own behavior, my lord, lordship may presume that how he himself has done. My lord,
You
saying
will-
that,
What is your submission?
my lord, I will, my lord, comply, my lord.
Learned counsel for the petitioner submits that though the permanent residence of the present petitioner is in village Bordolguri under Sipadhar police station in the district of Darang, but before the incident, he was residing at Dokhingaon under Hatigao police station, and he has assured that he and learned counsel for the petitioner has submitted that the petitioner is ready to face trial and shall cooperate in his trial. Stop.
One thing may be recorded, my lord. Though charge was framed on 19/1/23, no progress has been made in the trial, my lord.
Learned, I have also heard learned additional public prosecutor. Stop. Who has pointed out from the scanned copy of the case record, which is available before the court, that though the charge was framed against the present petitioner on 19th of January 2023, but till date, no witness has yet been examined. Stop. Considering the aforementioned facts, as well as considering the prolonged incarceration of the present petitioner, as well as his conduct that of he himself surrendering before the police after the incident, this court is of considered opinion that if he cooperates in his trial, his continued detention may not be necessary for fair completion of the trial. Hence, in view of above, the petitioner Mridul Ahmed is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned.
Additional session number 2, Kamrup Metro.
Learned additional session judge number 2, Kamrup Metro, Guwahati, who may add or invoke any other additional condition, additional bail condition at the time of accepting the bail bond. With above observation, no, before accepting the bail bond. Okay. With the above observation, this bail application is hereby.
Number 12.
12 मतलब charge sheet submitted मतलब with to the instruction मतलब
46 days, my lord, behind the car, my lord. From the FIR, my lord, offense, my lord.
12 is anticipatory bail.
439.
no,
439, my lord.
439.
You appear before the trial court, pray before the charge sheet has been laid.
He's in custody, man.
Now, therefore, you are before us. But after submission of charge sheet, the trial court is the best court. You first appear before us. Heard Mr.
Not R. Ali, my lord.
R. Ali. Your name is not
Not there, my lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid by charge sheet number
74/23 dated 20/10/22.
Stop. In view of the laying of the charge sheet against the present petitioner, this bail application is disposed of with an observation that the petitioner may approach learned trial court and may pray for regular bail before learned trial court, comma, if so advised. Stop.
Twenty.
20 instruction at present we have not received, my lord, whether he appear or not, my lord. But they have shown that regarding one person charge sheet submitted, but this petitioner's name was in the charge sheet or not, my lord. We have
My lord, I have appeared before the IO 17/5/2023. And thereafter, statement was recorded, and there were two accused persons. One is Karimul Haq. Against Karimul Haq, charge sheet was submitted. Thus now I have confirmed.
Against you, charge sheet.
No, my lord.
No, but this instruction, my lord.
When
Thus now I got the virtual message.
when your own sources are not strong, you should take help of.
My lord.
Yes, man, I have confirmed it.
Yes, yes, my lord, this is not
What is
certified.
that? What is that?
The charge sheet was submitted against Karimul Haq, and DNA report.
Otherwise, we may make it absolute if required.
My lord.
My lord.
Heard Mr.
MP Borana.
N.P. Bora, learned counsel for the petitioner. Also heard Mr. K. K.
Accordingly,
Parashar, learned additional public prosecutor. Learned counsel for the learned additional public prosecutor has submitted that though the updated case diary along with DNA report was called for, however, same has not yet arrived. He has also submitted that he has failed to contact the investigating officer after trying to do so during the lunch period today. On the other hand, learned counsel for the petitioner has submitted that the petitioner was allowed to go on interim anticipatory bail on 15 by order dated 15/5/23, and in pursuant to the direction of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Learned counsel for the petitioner has also submitted that he has been informed that in the meanwhile, charge sheet has been laid against the co-accused Karimul Haq, and the present petitioner has been exonerated. Stop. In view of the submissions made by the counsel for both sides, the interim anticipatory bail granted to the present petitioner by order dated 15/5/23 is hereby made absolute with condition number 2, 3, and 4 attached to the said order remaining intact. With above observation, this anticipatory bail application is thereby disposed.
Much obliged.
The connected IA, what is this IA?
My lord, the petitioner was a physically disabled person, and I have annexed the disability certificate along with the IM.
I may be along with close my lord.
In view of the in view of the disposal of the main anticipatory bail application number 1688/23, this IA stand closed.
Much obliged.
55.
This revision application has been filed challenging the impugn order dated impugn order dated 7/9/2023, Annexure K, page number 52. Whereby the learned court below has framed charges against the petitioner accused person under section 365/511 T23 on the point of hearing, your lordships. The charge has been framed, both sides.
Charges are framed
Charges are framed
after hearing both the sides.
after hearing both the sides, your lordship. The counsel for the petitioner has pleaded to discharge the petitioner on the point of these sections, your lordship. But the negating those submissions, your lordships, the learned court below has framed charges against the petitioner. Without going to the entire materials of the case, is the court below, without perusing the FIR, lordships, may I go back to your FIR?
No,
please?
let us then call for the scan copy of the case report and issue notice.
And notice to the go.
And your lordship, may I pray because this order may be time being stayed, your lordship.
No.
If evidences has been gone by your lordship, then this petition will be in process, your lordship. And the case is in the evidence stage, your lordship. Let the trial may proceed. Let the record may be called for. Till then, your lordship, please.
No,
Evidence.
but for staying the operation of the impugn order, some defect has to be shown prima facie.
Lordship, the defect
And
is-
to examine your submission, we will require the scan copy of the case record.
Lordship, the very substance, your lordship, 365, the basic ingredients is not there, your lordship. If you go to the entire documents, more fully, your lordship, the statement of the victim. The accused is a related person, first of all. He's aged about 16 years. The definition says for kidnapping is for a male person is below 16 years. Now, second is he has not been
No,
taken.
let us go through the, if
Now, I have annexed this statement of the victim, your lordship, as well as the informant and the other witness. And more fully, your lordship, before framing the charges, no 164 statement has been produced, your lordship. No, there is no 164 statement. That is a vital part and piece of the lordship evidence for before framing the charges. Your lordship, if your lordship kindly go to the
No, 164 statement were not there.
no there. That is why, lordship.
It may not be there.
No. And the main vital witnesses. Now the IO in framing of charges, the charge sheet, the IO's name has not been included. Number one, no doctor name has been included. Now the other related witness, they are not also been made prosecuted witness in the case, your lordships. This also signifies that entire case has been framed out. And it's a false case against the petitioner. If you kindly go to the victim statement,
Where is the list of witnesses?
lordships, I have annexed the case 32, your lordships. This is type copy of the charge sheet. The number one, the column is name and witness of the address of the witness. That point to the point is called to prove.
Only 3 witnesses.
Only 3 witnesses. Number one is
Maybe prosecution thinks that 3 witnesses are enough.
now, where is the IO, your lordship?
May not be required.
Lordship. If you lordship that consider now, if you lordship kindly go to the statement of the victim, the PW2 and the PW1 and the
No,
FIR.
we will examine your submission. We are issuing notice. We are calling for the scanned copy of the case record.
No,
Then suppose if you succeed in convincing this court, later on the charges will be quashed.
Yes. But the thing is that for framing of charges 365, your lordship, that there is some ingredient is there, kidnapping and abduction. The very instant case, three ingredients are missing. That is why I come before your lordship to.
When is the next date fixed?
Today is the date that has been fixed, but
Next date.
today is the date. Today is the date fixed, but I have not got the instruction. The matter has been deferred or postponed or not. Your lordship, the date has been fixed, but the impugn order, your lordship, kindly, the date has been fixed for 8/11 for evidence. Today is the date has been fixed for evidence. Your
What has happened today?
I have.
You seek instruction.
I have instruction that I think the court has adjourned the case.
Till what is the next date?
No, I have not got the next date, your lordship.
Find out.
Lordships.
You get instruction. What is the next date? We will fix this case before next date.
Lordship.
Quick scan copy, yes.
Lord.
Because
Okay.
of Kamrup Metro, my lord.
Kamrup Metro, your lordship. CGM Kamrup.
You tell us the next date of the case.
Mobile.
But some lawyer is representing.
Yes, some lawyers is representing.
You contact
Lordship.
that lawyer and
Lordship.
tell us the date.
Lordship.
Now, Mr.
H. Burala.
H. Borwa, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 397 of the Code of Criminal Procedure 1973, read with section 482 of the said code, has been filed by
Yes,
petitioner Shri Kushal Borwa, impugning the order dated 7/9/2023 passed by learned Sub-Divisional Judicial Magistrate number 2, Kamrup within bracket Metro Guwahati, in connection with PRC case number 796/2018, whereby charges under section 365/511/2323 under Indian Penal Code has been framed against the petitioner. Issue notice to the respondents and call for the scanned copy of the case record of PRC case number 796/2018 along with the scanned copy of the which police station case?
It's a Panbazar police station.
What is the number?
Lordship.
What is the PS case number?
PS case number is FIR, PS case number is 386/16.
Along with the case diary of the Panbajar PS case number 386/2016.
16.
As learned additional public prosecutor appears on behalf of respondent number 1, no formal notices need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from date of this order, returnable on. You give me the date.
Lord, I will
Returnable on dash.
I will inform.
Keep it blank. Let this case be fixed again on. Keep a blank. You furnish the.
Lord, I will inform you. Officer, Lord, Lieutenant. Sir. Item 38.
May I please? This is a clearest bail application, Lordship. The CD was called for.
28/11. The next date has been fixed for 28/11.
28/11.
Your Lordship, for evidence.
But then you have to take. It cannot be 28/11.
Because
It would be too short.
yes, notice should go, my lord.
4 weeks or a date. Sorry, of third. Commentary. After 4.
Today is 8.
14/12.
Lordship.
A blank 1 14/12.
Lord.
Yes.
Clearest bail application, Lordship. The CD was called for, Lordship.
CD available.
Yes.
Lordship, in paragraph number 4 of my bail application, Lordship, I have stated the reason of lodging the FIR, Lordship. And the FIR was lost after 11 days of alleged date of occurrence, Lordship.
In para 4
of my bail application, Lordship, there is a nexus in of the informant with the local, some of the local people. She is separated from husband and trying to compel the petitioner, compel her to marry, Lordship. As per the FIR, Lordship, the incident was occurred on 21st day of August, Lordship, and the FIR was lost on 1 September of 2023, Lordship, which is only because reason is that, Lordship, the reason of delay is that in medical, in case she lost the FIR as soon as the incident occurred, Lordship, then in medical examination, she caught that she has falsely alleged the allegation. That's why she has lost the FIR after 11 days, Lordship. But he is a local people and he will help the IO in investigation of the case, Lordship. And the custodial detention is not necessary in this case, Lordship.
My lord, in the case there is 161st statement of the victim is available. As per the 161st statement, my lord, while she was in the paddy field, my lord, and this accused, my lord, took her to a nearby jungle and raped her, my lord. In the at that time when she made the hue and cry, my lord, one person seen the incident, my lord, and that person, but she said that I don't know the name of the person, but he is my nearby village. And one Sumeshwar Brahma, my lord, his statement is, he is also 161st statement is available in the CD, my lord. He said that one at about 10 a.m. Malat. He heard Malat hue and cry, Malat, and he went to the nearby jungle and saw the accused is doing the paddock with this informant. And both are 164 statement, Malat.
So what is it, sir?
So, Malat,
Considering the nature,
no, Malat, at this place, Malat, he is anticipated bail, Malat.
Already lordship in from
This
the
type of-
CP, it is apparent that the investigation is already completed.
whether
Most part of the
Custodial interrogation, Malat,
custodial interrogation is not
in-
necessary, lordship.
in such type of cases, Malat, custodial interrogation is necessary because, Malat, yes, 164 statement are there, but his interrogation is also necessary, Malat.
Mr.
UB Sharma.
UB Sharma, and counsel for petitioners. Also heard Mr. K.K. Parashar, and an additional for the prosecutor. This application under Section 438 of the Code of Criminal Procedure for 1953 has been filed by one Ramzan Ali, who is apprehending his arrest in connection with Amguru PS case number 40/2023 under Section 376 of the Indian Penal Code. The gist of accusation in this case is that the victim / informant of this case caused an fire before the officer in charge of Amguri police station, on 1/9/2023, inter alia alleging that on 21/8/2023, when she went to Pashchim Bhawanipur field to graze her cows, the petitioner dragged her to bamboo farm and forcefully raped her. And thereafter, after seeing a boy coming near that place of occurrence, he threatened her to kill. He threatened the victim to kill her if she tells the incident about anybody else and ran away from there. It is stated in the FIR that delay in lodging the FIR was due to the fact that the informant approached village heads to take a decision in this regard. Learned counsel for the petitioner has submitted that the petitioner is innocent and is no way involved in the offense alleged in the FIR. It is submitted that the contents of the FIR are false, and there is no plausible explanation given in the FIR for the delay of 11 days in lodging the FIR. Learned counsel for the petitioner has also submitted that, in fact, the victim is a woman separated from her husband, and she is insisting the petitioner to marry her. And when the petitioner refused to do so, she lodged a false FIR against the present petitioner. So, however, on the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the present petitioner and has produced the case diary of Amguri PS case number 40/2023, which was called in connection with this case. Learned additional public prosecutor has submitted that there are sufficient incriminating materials against the present petitioner in the case diary. He has pointed out to the statements made by the victim girl and two other one other witnesses recorded under 164 CRPC, wherein they have specifically implicated the present petition. Stop. I have considered the submissions made by learned counsel for both sides and have perused the materials in the case that though the petition learned counsel for the petitioner has submitted that the petitioner is innocent, however, there are sufficient incriminating material against the present petitioner at this stage in the case that, and considering the nature of offense involved in this case, this court is not inclined to give the benefit of an order under section 438 of CRPC to the petitioner at this stage of the proceeding. Hence, the prayer for anticipatory bail is rejected.
Item
Hello.
39. May I please alert you? My lord, there are, my lord, three petitioners, my lord. Petitioner number 1 and 3, husband and wife, my lord. Petitioner number 2 is brother, my lord, of petitioner number 1, my lord. FIR, my lord, page 9, lecture 1. May I read, my lord?
Yes.
About the incident, I, Biresh Chaudhary, beg to state that today, Friday on 18/8/2023, at about 12 noon, 5 persons of my neighboring house, taking advantage of loneliness of my wife, namely Jalakti Chaudhary in the house, came to the corridor of my house, thereby outraged the modesty of my wife and tried to kill her. The said 5 persons are namely Dulal, the son of late Kumud Das, Suvarna Das, wife of Dulal, Babban Das, brother of Dulal, Shivani Das, elder daughter of Dulal Das, and serial number 5, Riya Das, younger daughter of Dulal Das. The aforesaid 5 persons came to the corridor of my house armed with chopper, hammer, broom, and rod. Dulal Das and his brother outraged the modesty of my wife and tried to kill her, and from the backside, Dulal Das fractured the head of my wife. As a result, she lost her, and when my aged mother proceeded to prevent such assault, she was pushed and choked. Because of such outraging modesty of my wife and for trying to kill her, it is hereby demanded that they 5 persons should be punished to which they deserve. Since few months, the wife of Dural, namely Suvarna, has used to abuse my wife, Jalakti, with bad language and used to give her the death. My lord, actually, my lord, on the day of my lord, they are, my lord, neighboring, my lord, 2 families, my lord. And they have, my lord, personal grudge with each other, my lord. And on the day of, my lord, incident, my lord, some relative, my lord, with some, my lord, marriage proposal came to the house of the petitioner, my lord. And they, my lord, intentionally tried to, my lord, quarrel with the petitioner's side, my lord. Therefore, my lord, some, my lord, altercation taken place, my lord. Nothing serious was happened, my lord, as per my instruction, my lord. Therefore, my lord, the lower court also, my lord, London Session Judge also granted bail, my lord, accused number 4 and 5, my lord. But rest 3 persons also, my lord, preferred bail, my lord, but their bail application was rejected.
4 and 5.
4 and 5, my lord, granted.
Anticipatory bail.
Anticipatory bail.
Why your prayer was rejected?
It was, my lord, I have annexed, my lord, observation, my lord, is page 18, my lord. Page 18, my lord, the second paragraph, my lord. However, on meticulous scrutiny of the case diary, including the injury report of Srimati Jalakti Chaudhary, this court is of the considered view to hold that if at this stage the other accused persons are also allowed to go on bail, the same will affect the proper investigation of the case.
What is the injury?
Injury, my lord, head injury, lacerated injury, my lord.
Lacerated.
And my lord, lacerated. And my lord, there are eyewitnesses to the independent eyewitnesses to the occurrence. My lord, petitioner number 2 and 3, my lord, so far petitioner number 1 is concerned, my lord, there is serious material against him. My lord. He has assaulted with a hammer the victim, and independent eyewitness is there. My lord. Now, petition number 2 and 3, they, my lord, abused the, my lord, victim and victim's family, and there is no, my lord, assault part there. But I have objection to, my lord, petition number 1. A lady has been assaulted by him with a hammer. My lord.
No, what is the progress of the
My lord, progress is made. Witnesses are examined, my lord, and independent witnesses are also there. Neighboring people came and saw the assault part by the inflicted by the petitioner number 1, and that is corroborated by medical evidence.
My instruction is that, my lord, the injury are simple, my lord, not serious, my lord, and they are provoked, my lord. My lord, they always, my lord, they are, my lord, eligible daughters, my lord, in the house, my lord, and they always try to blame, my lord. On that day, my lord, also, my lord, outsider came to their house, my lord, and they intentionally, my lord, tried to.
What injury has?
Injury is not reverse.
What
Simple injury,
nature of the injury?
Mild injury. But he came with a weapon, my lord, mark. That is there.
But let him face trial.
I leave, I have objection so far. Petition number 1 is concerned. That may be recorded.
Mr. A. Empowerment and the counsel for the petitioner. Also, our Mr. T. Das, petitioner for this application under section 438 of Code of Procedure has been filed by 3 accused persons, 3 petitioners, namely Dulal Das, number 2 Sujit Das, alias Babon, number 3 Subhana Das, who are apprehending their arrest in connection with Panchigram PS case number 74/23 under section 447/145/354/325/294/506 of the Indian Penal Code. The accusation against the present petitioner is that on which date? On 18/8/2023, one Shri Biresh Chaudhary lodged an FIR before the officer in charge of Panchgura police station, inter alia, alleging that on that day, that is 18/8/2023, at about 12 noon, 5 accused persons named in the FIR, including the present petitioner, trespassed into the house of the first informant and outraged the modesty of the wife of the first informant, and also assaulted the wife of the first informant. First informant from backside and caused fracture in her head. Fracture is not
fracture.
So
Lacerated wound.
FIR is the exaggerated.
My lord.
FIR is the exaggerated.
Exaggerated.
Fracture in her head. Learned counsel for the petitioner submits that there was some altercation between the present petitioner and the accused, other 2 accused persons named in the FIR, and the with whom you had altercation.
My lord, wife of the informant.
The injured.
Yeah.
and the wife of the informant. However, the allegations made in the FIR is not true, and it has been exaggerated. So it is submitted by learned counsel for the petitioner that in the meanwhile, learned Court of Learned Sessions Judge, which court has granted bail to 4 and 5
Additional session judge.
Learned Court of Learned Additional Sessions Judge Hailakandi has allowed the accused number 4 and 5 named in the FIR go on anticipatory bail. Learned counsel for the petitioner has submitted that the petitioners are ready to cooperate in the investigation and therefore praise for allowing the petitioner to go on anticipatory bail. On the other hand, Mr. D. Das, learned additional public prosecutor, has produced the case diary of Panchgram PS case number and has submitted that there are incriminating materials against the present petitioner. He has vehemently opposed the grant of bail petitioner number 1, Dulal Das, on the ground that he assaulted the informant who is a woman with
Not informant, informant's wife.
Informant's wife who is a woman. The informant's wife who is a woman is not required. Informant's wife with a hammer. Stop. However, learned counsel, learned additional public prosecutor has fairly submitted that the injuries found in the injury report available in the case diary are simple in nature. Considering the facts.
The exact word is used mild injury.
Mild in nature. Mild is
M-I-L-D, mild.
is lesser than simple or more than is mild in nature. Mild. Considering the fact that 2 of the co-accused are already allowed to go on anticipatory bail by the Court of Learned Additional Sessions Judge Hailakandi. Also considering the progress made in investigation as well as nature of the injury sustained by the victim, this court is of considered opinion that custodial detention of the present petitioner may not be necessary for fair completion of the investigation of this case, if they cooperate in the investigation. Stop. In view of above, the above named petitioners are directed to appear before the investigating officer of Panchgram Police Station, case number 74/2023, within a period of 10 days from the date of this order and cooperate in the investigation. So if they do so within the stipulated period of time, in the event of their arrest in connection with Panchgram PS case number 74/2023, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1, the petitioner shall not directly or indirectly make any inducement, threat, or to the informant, his wife, or any other person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts before the investigating officer or before the court. Number 2, the petitioner shall cooperate in the investigation and shall appear before the investigating officer as and when so required by the investigating officer for the sake of fair investigation. With above observation, this anticipatory bail application thereby disposed.
Diploma. Item 40.
Well, in this case, well, the wrong city came actually, well, in the Custodial, they have made the mistake that Lala. It should be Lala PS. They have written as Hailakandi PS. So Hailakandi PS CD 249 has come. Well. So it should be Lala PS 249. Well.
So we have to wait for that.
Till then, may otherwise, lordship allegation is lordship wrongful restrainment, previous.
How much time would be required?
No, this side, Kasar Karim Hailakandi.
What is the allegation?
Allegation is lordship 341, 326,
326, 295,
307, 34. Allegation is a lordship against unknown person lordship, but only corroboration is lordship. My two-wheeler vehicle was seen in the place of occurrence.
Let them appear. In the meanwhile,
regarding that, 326 and 307, I have approved. 326, I'll try at best that on 20 Monday.
Okay, let us wait for one more day. On that day, we will decide. Heard Mr. D. Doloy, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who submits that due to wrong mentioning of the full name of the police station in the cause title of the anticipatory bail application, the correct case diary could not be requisitioned. And the case diary has to be requisitioned from Lala police station.
Lala.
And for which learned additional public prosecutor seeks some more time. The prayer is allowed. Let this case be fixed again on 20th 2011. On that day, if the case diary does not appear, is not produced, the prayer for interim anticipatory bail shall be considered.
41.
Here, two cases came, was called for Malad, and they are seeking bail in 182, Karupedia 182 up 23. On cross case, 181.
But if this case has been wrongly listed.
Oh, yes.
This case has been on 10-11.
And this now today 3623 of 23 is before,
because
but it is not listed in the cause list.
Originally, it was not file was not there. File was in respect of 2022.
Item number?
Item number 41.
Item number 41 is 3623 of 23.
Okay.
Now the record before me is also 3623 of 23, but it was listed on 10th of tomorrow. Okay.
It is directed to be listed on 10-11.
Case diary has arrived.
Case diary has arrived, both case diary, two case diary came, was called for, but here injury report is required, 326 is the, in both the cases, both sides there is scuffle,
relating to child marriage. And the case 3623 of 22 lordship, that was relating to Parvati. And that I have taken, and that case is fixed on today.
This is a child marriage case. You have case diary of
Karupetia 182 of 23 and 181 of 23.
Now this is Tamarhat PS.
Yes, sir.
132.
And that case diary is related to lordship AB number 3623 of 22 lordship.
Which is not listed today.
Yes, Lord, but at 10, 15, Lord, I have checked that file was there.
Okay. You have actually,
Oh, sorry.
I have understood. Heard Mr. R. Islam, learned counsel
Yeah,
for
that
the
should not come, my lord.
learned counsel for the petitioner. It appears from the order dated 19/10/2023 that this case was listed on 10/11/2023 and and therefore it appears that it has been wrongly listed today in the cause list. Let this matter be again listed on 10/11/2023. Because on that day, case diary may arrive.
My lord.
And Lordship, interim bail granted to the petitioner number 2 may
The interim order
on 19/10.
interim order shall continue till next day.
Step 42.
42, my lord, CD not received. Today is the first day, my lord. CD and medical report are called for, my lord.
My plea, your Lordship, my lord.
326,307.
My lord, this FIR, my lord, is an effect of earlier 2 FIR, my lord.
No, but last order has been specifically mentioned in the
Well,
last order
well.
that only after perusal of the
And other two CD of other 2 PSKs may be called for, my lord. Mankasar PSKs
that
260.
you may make submission. We are concerned with the allegation made against you in this case. Regarding other 2 cases which may help you, you may make submission. We will consider your submission.
Yes, your lordship, kindly see them, my lord.
Not
Okay.
now, not now. On the next day.
My lord.
Heard Mr. M. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived, and prays for some more time for producing the case diary. The prayer is allowed. Let this case be fixed again on
Mankasar on, my lord. 22nd, my lord.
Some short date may be given because he's not, they are not in interim, my lord.
On 20, my lord, 28.
2011. This is the short which is available with
My lord.
PP. 20.
Item 43.
Highly obliged.
In this matter, my lord, 438 bail application CD is called for. Before perusing the CD, my lord, may I submit, my lord, among the petitioner number 10, after filing of this petition, was arrested, my lord.
Who is arrested?
Petitioner number 10, after filing of this bail petition, he was arrested, my lord. Reza Ali.
Here also, my lord, injury report is not available. Injury report is required, my lord. CD, though available, my lord. 326 and 379.
In the FIR wherein, my lord, we are seeking anticipatory bail is the cross FIR of another FIR which was filed by us, your lordship. And the original fact is that, my lord, on the basis of a land dispute, my lord, the relatives of the informant has attacked our home, my lord, your lordship, and thereafter assaulted us, and 2 of us have suffered previous injury. I have annexed the photocopies of both those 2 petitioners, my lord, with my petition, my lord.
Abdul Jalil.
And what is the allegation against you?
Allegation is that, my lord, the petitioners were attacked the residents of the informants, and thereafter, my lord, assaulted them. This is the allegation located in the FIR. FIR is at page number 22, my lord. It's a long FIR, my lord. And 7 family members and other persons were incorporated in the FIR, my lord. And among them, there are ladies also, your lordship. And out of them, my lord, two persons, your lordship, in petitioner number, your lordship, 3 and 4 got serious injuries on the attack made on them by the family of the informant, your lordship. And I have annexed the photocopy also, your lordship. The attack was made on us, your lordship.
No, who suffered injury from?
Had petitioner, your lordship. Two
No, no,
petitioners,
I'm
number
not,
3 and 4,
not concerned about petition FIR filed by you now.
my lord.
FIR filed against you. What is the allegation against?
My lord, that affair is at page number 22.
Yes.
And the
In that FIR, what is the allegation?
may I read the Bhanipular one, my lord?
No, you may tell me the gist.
May I read, my lord? Today, that is on 14/9/2023, at around 3:30 a.m., a group of hired goons armed with stick, knives, daggers, fire, and various weapons entered our house while we were sleeping in bed and broke the door. They suddenly started attacking us while we were in bed, and while beating my husband, they dragged him down from the bed, tied him to pole, and beat him with the
What is the name of the husband?
Name of the husband is Shah Alam.
No. Injury report is not there. Huh?
Not there.
Okay. Okay. Then
My husband seriously injured and become senseless. When I saw the accused person beating my husband, I ran to my father-in-law's house about 50 meters away. A group of goons hired by accused persons left my husband unconscious and completely broke my house and looted tin sheet and all the belongings. They also tore my clothes, neck, and injured my sister-in-law, Sabina Yasmin, sister-in-law, Umme Hani, my niece, Zahan Akhtara, and Suhana Begum, and touched their genitals. And my sister-in-law, Sabina Yasmin, was stabbed with a knife, and her head was torn, and she bled heavily, and she fell unconsciously on the ground. Thereafter, the accused beat me along with my sister-in-law, niece, and my parents-in-law, and vandalized my father-in-law's Bolero car carrying Sonchonova in the compound of the house, and ruined all the belongings inside the house, and looted rupees 60,000 in cash and gold jewelry. After the accused left the locals, took us to Kharipati hospital, immediately come to know the chaos. But my husband, my father-in-law, my sister-in-law, Sabina, and my two nieces were in critical conditions, and they were sent to Mongol Civil Hospital. My husband was admitted to Guwahati Medical College as his condition is serious and is currently admitted to GMC in critical condition. But whom they made many persons incorporated in the FIR, but who beat them? That is, nothing has been disclosed here, Your Lordship. And this is the cross FIR, my lord.
Injury report is required, my lord, because witness
because on last
examined the
occasion also there is an observation that injury report is necessary.
witness examined, my lord, are most of all, my lord, family witness, my lord, not there. And injury report is vital, my lord, because both way, my lord, in the both the case, my lord, allegations are there, my lord.
My lord, only one prayer, my lord.
When can you produce the case? Injury.
Kharipati, my lord, on 17, my lord.
But at least interim protection will be given to some of the petitioners, my lord. There are ladies and 2 persons are injured seriously, my lord, on the attack made on them by the informant.
Who are injured?
Abdul Jalil, petition number 3, and Sukur Ali. I have annexed the photograph. Even Abdul Jalil's hand was severed, my lord.
Injury report is there.
That I could not annex, but the photocopy I have annexed, my lord. And because we are
which page?
And if I look at page number 47, my lord. 47 is the photocopy of the hand of Abdul Jalil, and 48 is the Sukur Ali, my lord. And there are lady also, my lord, petitioner number 5, 6, 7. They are sister and wife of the other petitioner, my lord.
Okay.
They may be, my lord, protected, my lord.
They are severely.
Yes, that's what a photograph, my lord.
And even if could not submit the injury report because against us, my lord, FIR is closed. Therefore, if anyone go appear, man, they will be arrested, my lord.
No, are you in a position to go and appear before I?
Now, my lord, they can go, my lord, because they are discharged, my lord.
Abdul Jalil
and Sukur Ali.
Sukur Ali and
petition number 3 and 4.
3, 4, 5, 6, 7. 5, 6, 7 are lady, my lord. They are family members.
7 is also good.
My lord, 7 is the wife of the petitioner number 1, my lord.
Very full.
And petitioner 6 is wife of my lord, petitioner number 2, my lord. And the petitioner 5 is the sister of the petitioner number 1, 2, 4, my lord.
Yes, my lord, this 3, 4, 5, 6, and 7. At this stage, my lord,
They may be protected at least.
my lord.
Third, Mr. This is item number.
43, my lord. MAI.
Third, Mr. M.A.I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of criminal procedure, Code of Criminal Procedure, has been preferred, has been filed by 10 number of it, has been filed by 15 numbers of petitioners, namely, you write the name, namely, who are apprehending their arrest in connection with Karupetia PS case number 182/2023 under section 128/448/427/325/427/326/379 of the Indian Penal Code. It appears from the record that by order dated 27/10/2023, the case diary of Karupetia PS case number 181/23 as well as 182/23, along with the medical report, were called for in connection with this case. Learned additional public prosecutor has submitted that though both the case diaries are available before the court, however, the injury report has not been sent by the investigating officer. It is further submitted by learned additional public prosecutor that for consideration of the instant bail application, considering the nature of the pleas made by the petitioner in their bail petition, the perusal of the injury report would be necessary. Stop. Hence, call for the injury report. Fixing.
My lord, as already, my lord, interim granted to those
Some of
person, my lord. Then, my lord, on maybe fix on 22nd, my lord.
Fixing 22nd November for injury report. The case diaries may be retained or you will be sending.
My lord, maybe written, my lord.
Case diaries may be retained till the next day. In the meanwhile, learned counsel for the petitioner has submitted that petitioner number 3, Abdul Jalil, and petitioner number 4, Sukur Ali, sustained grievous injuries in the incident involved in this case, for which a counter FIR has also been lodged. Now,
It is a counter.
okay, for which an FIR has also been lodged by the side of the petitioners before
Petition
the
number 5 log the FIR.
by petitioner number 5, Sajida Khatun, before the lodging of the FIR in the instant case. In support of his submission, he has produced 2 photographs stated to be the photograph of the petitioner number
3 and 4.
2,
3 and 4.
3 and 4.
Abdul
And on
Jalil.
perusal of the state photograph, it appears that the injuries shown in the state photograph appears to be grievous in nature. Learned counsel for the petitioner has also submitted that the petitioner number 5, 6, and 7 are women, namely Sajida Khatun, Sena Bhanu, and Zariful Khatun. Learned counsel for the petitioner has submitted that considering the nature of injuries sustained by the petitioner number 3 and 4, and considering the fact that petitioner number 5, 6, and 7 are women, they may be allowed to remain on interim bail till arrival of the case. The prayer is allowed. The petitioner number 3, 4, 5, 6, and 7, namely Jalil Ali, Sukur Ali, Sajida Khatun, Sena Banu, and Veriful Khatun are hereby directed to appear before the investigating officer of Karupetia PS case number 182/23 within a period of 10 days from the date of this order and cooperate in the investigation. So if they do so within the stipulated period of time, in the event of their arrest in connection with Karupetia PS case number 182/23, they shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to the condition that the petitioner shall not make any promise, threat, or inducement to any person who is acquainted with the facts of the case so as to dissuade such person from disclosing such fact before the investigating officer or before the court. Number two, the petitioners who are granted interim bail shall the petitioners who are granted interim bail shall cooperate with the investigating. Let this case be fixed again on 22nd.
One thing, my lord has dictated as Jalil Ali. It's Jalil alias Abdul Jalil.
Jalil alias Abdul Jalil.
Abdul Jalil. Hello.
Only for my CD not received, my lord.
The CD is not there. I'll only make two short submissions. In this case, there are two families who are in dispute over a piece of land measuring 10 letters. Now, it is my land. I say that they have encroached. They say that I have encroached. So, there is a dispute regarding a matter which is of a civil nature, primarily. Now, because of this dispute, there are cross FIRs. Cross FIRs are filed 18 hours and 19 hours after the fight that has happened between the two families. Now, the reason why there is a delay in both of these FIRs, I have mentioned in my bail petition at page number 4. It's because the villagers had intervened and we had compromised. Later on, someone from their side went to the police station and they said that no, file the FIR. People are injured. Now, on both sides, Milods, there are injuries to people. It is a conceded position. The difference between the cross FIRs, Milods, against me, all three petitioners here, there are no specific allegations. In fact, there is no specific allegations against anybody. Milods, page 15 is their FIR against me. They have only provided a list that these are the people who encroached on the land, and some people had come with da and daggers. And the informant says that her father-in-law and some of her relatives were injured. Who injured them? How were they injured? Nothing is specified. On the other hand, Milods, to the contrary, my FIR, which is at page 22, Milods will find that what we have done is what any reasonable person does. We have also provided a list of accused persons, but we have said that accused number 1 is the person who came with an iron rod and a dagger, and he was the one who stabbed and hit people. And we have specified the people who were injured. In fact, Milods, petitioner number 3 was quite grievously injured. It's there at page 22, Milods, in our FIR. Therefore, Milods, my humble submission is that Milods, interim anticipatory bail may kindly be considered till the CD comes, and the injury reports may also be called for if the learned PP thinks that it's necessary, or the learned court also, honorable court also finds it necessary. So in the interim, Milods, my humble prayer is that it may be considered interim bail, because my FIR is also there, Milods. The investigation in that FIR is also stalled because I can't go to the police station due to my application.
Mr.
A. Gautam, Milods, on behalf of Mr. A. Ali, he's medically unfit.
Mr. A. Gautam, learned counsel for the petitioners, also heard Mr. K. Parashar. Mr. Parashar, when you can produce the case?
Dolgaon, my lord,
I'm granting them interim.
My lord, then, my lord, on 30th of November, my lord.
Also heard Mr. K. Parashar, who submits that though the case diary which was called for however, same has not arrived, and prays for some more time for producing the case diary. On the other hand, learned counsel for the petitioner submits that In the meanwhile, the petitioners may be protected by allowing them to go on interim bail. The facts of this case is that the petitioners, namely Wazib Ali, number 2, Fulesa Khatun alias Fulesa Begum, Wazib Ali alias Wazid Ali, and Hazeb Ali have approached this court by filing an application under section 438 of the Code of Criminal Procedure, 1973, apprehending their arrest in connection with Dolgaon PS case number 350/2023 under section 143/147/326/325/307 of the Indian Penal Code. The gist of accusation in this case is that on which date of affair?
8th of October 2023.
On 8th of October 2023, one Khazida Begum lodged an FIR before the officer in charge of Dolgaon Police Station, inter alia, alleging that on 2nd of October 2023 at about 1:30 p.m., the accused persons named in the FIR, within bracket total 10 accused are named in the FIR, including the present petitioner. Bracket close. Named in
I'm sorry, 8th October. The translation is wrong. 8th October.
8th October. Then there is no delay in FIR.
No, there is. It was lodged 18 hours later, next evening. 1:30 a.m. the incident happened. 7:30
Instead
p.m.
of 2nd of October, 8th of October. What was the last? Petitioner trespassed into the land of the first informant armed with da and dagger and constructed one house there. When the father-in-law, namely father-in-law of the first informant, namely Alfaz Ali, went there, the who was assaulted? He was a stop. Learned counsel for the petitioner has submitted that though the incident occurred on 8th of October 2023 at about 1:30 a.m. at night, there was a delay in lodging a FIR by about 18 hours. It is also submitted by learned counsel for the petitioners that there is admittedly a land dispute between the parties, and the petitioner side also lodged an FIR, cross FIR against the other side, and later on the matter was amicably settled between the parties. Then, if it was when it was settled?
No. After the settlement happened, somebody from their side went and filed the FIR. After that, we filed our
Khazida.
FIR.
This Khazida.
Yes, Khazida
Khadija.
filed it first, and then we filed it. We're consecutive FIRs, 350, 351.
This was after the settlement.
Yes, yes. After the settlement happened in the village.
It is also submitted by learned counsel for the petitioner that the present petitioners are not specifically named in the FIR. We have a meeting. I'll dictate the remaining part in the chamber, and the petitioners will be allowed to go on interim bail of rupees 30,000 with one surety of like amount. Next date will be on
13.
3011.
Very great.
Regarding item 46, Lordship, there was an interim order, Lordship. On the last occasion, it is due to overlook, Lordship. The non-appearance was there and court vacated the interim order, Lordship. Only that much clear, Lordship, to continue the interim order. Item 46. Lordship, continue the first interim order, Lordship.
Or vacating the.
No, not vacating, Lordship. That was non-appearance was given and thereafter, Lordship.
It got overlooked. I'm not an informant, my lord.
Both sides we did not notice the case, Lordship. The matter was
You are
called.
the informant, you are not opposing.
No, it is a compromise, Lordship.
Okay.
Lordship, kindly, at least only, continue,
Item number? Item number?
Item number 46.
46. Learned counsel for the parties submitted that on last occasion, none appeared for the parties. Why none appeared?
No, due to overlook, Lordship.
Due to
Is the
oversight.
item.
And the interim order was vacated. However, it is prayed that the matter has already been compromised between the parties.
Interim order was passed on 9/3.
No, let us fix it tomorrow.
Lordship.
Tomorrow we'll go through the record and
Lordship, that will
fix this matter tomorrow, list this matter.
much obliged. Much obliged.
And other, yes.
47, madam, I'm waiting, my lord, today to your lordship. It is bail pending appeal. For last 6 months, other cases, it is a case for bail, madam. Maybe it is tomorrow, day after tomorrow, madam. 47. Monday holiday. So, Tuesday, madam.
Tuesday. And regarding other, the bench assistant, the bench court master will give.
Regarding 45, my lord, this is a short-sheeted case. My lord, CD was called for. Scan copy of the LCR is required. That may be modified. Scan copy of LCR
in 45.
45, my lord. CD was called for, my lord. So, my lord,
In
scan copy
45,
of LCR may be
the scan copy of the case record may be called for.
case record of PRC 1420 of 2023.
PRC case number 1020.
1420 oblique 23.
1420/23.
In the court of CGM Borbetown.
From the court of Chief Judicial Magistrate.
Item, my lord, item 49 already CD and scan copy already called for, my lord. It may be listed on Friday, my lord.
The bench court master will give date.
Lordship,
Lordship,
45 date may be kind.
Item 53, your lordship, for last 3 or 4 consecutive occasions, your lordship, item has been left out. CD also available. Your hearing matter, quashing FIR. 53. But we a young boy.
No, but what is to be done? The
376
cause list is prepared in such a manner.
Lordship.
Unless we finish the bail matter, we cannot go to hearing.
376 DA is there. So a young boy has been suffering.
When should we fix?
Short date may be given here.
So Munjal apni side. You consult with the court master will give a date.
Hello.
divide